Some for motion from the supplementary cost list, item number 3.
My lord, I'm challenging the notice.
Yes, Mr. Mohanto, I can see you.
My lord, I can hear your lordship, but now probably I'm out of the frame. Just a minute, my lord. Yes.
Yes, now I see you.
Yes, my lord. Sorry, my lord, I couldn't come physically over there. So I had to address from here only.
Kohima have very good video conferencing facility than the principal seat.
I see. It appears to be, my lord. It appears to be now.
Yes, tell me, what is your case here?
My lord, my case is that I have received a notice. I am a resident of Assam. I am here. I have received a notice from the Dimapur police station. The officer has given me a notice at page 15, lordship will find. This is a notice under section 35(3) of BNSS, asking me to appear before him in respect of a particular FIR that has been lodged there, and which is on the basis of which a GD entry has been made, GD entry number 24 of 2025, dated 21/1/2025. And this says, lordship will see the first para itself. First para itself, there, wherein they said, wherein on 21/1/2025, a written FIR received from Amit Mesh regarding a vehicle truck 14 tire that you promised to sell in a consideration amount of rupees 24 lakhs. And for this deal, Amit Mesh paid you rupees 10,000 as token money on 30/11/2020 by ATM transfer number so and so, and advance money of rupees 15 lakhs for the truck on 8/12/2020 by RTGS number so and so from Dimapur HDFCR so and so, HDFC Bank, Purana Bazaar so and so, promised to deliver the 14 tire trucks within 1 month, but you failed to deliver, and till now you did not deliver the truck, nor did you return the money. So he want that you appear before me. He says that earlier 22/2/2025, police station Dimapur for hence second notice issued to you for appearance on 18/3/2025 at such and such. Now, my grievance is whole cause of action arose here in Gauhati. The payment was made, first contract was made in Gauhati. Payment was made in Gauhati. Then he was also returned money, contract failed, I had to return money. Money was returned here at Gauhati. And the other private respondent, Amit Mas, he is from Karbi Anglong, resident of Assam. Therefore, there was no occasion to file the FIR there, and the particular police station has no jurisdiction in this case. The notice being wholly without authority cannot be allowed to operate. That is my case. The police officer do not have. He should have forwarded the, if at all he finds that this is a case made out, he can forward the FIR to the appropriate jurisdictional police station. That is my case. Simple case. And I will appear before. But here is a ploy to drag me and to harass me, put pressure on me. That's how the person has gone there. And the FIR has been filed there.
So here for the truck on Iman by RTGS so and so through HDFC Bank, Purana Bazar, Dimapur.
Yes. One payment was made from there. Nowadays, payment can be made from anywhere else. No issue. There is no problem. He may have paid that from that, but that will not change
What is
the
your
cause of action.
business? What is your business, Mr. Moto?
My business is, I'm a company. I'm
What?
having a company. A lot of people kindly see at page. Annexure 1, page 13. Okay? Plan Craft. This is the company. I deal with.
You are a company.
Yes, I'm a company. This 13, 14 lots will find this certificate so and so. I'm a company. I deal with many things, but this also for vehicles, there also I deal with. Therefore, second-hand vehicle, this was a second-hand vehicle, not the first-hand vehicle. I wanted to sell a second-hand vehicle to him. He came here. We entered into, first payment was made. Here, kindly see the receipt issued at page 16. Page 16, this is the handwritten one. Translation, next page, your lordship, 17. The first
Full booking amount must be clear.
agreement was this.
Refund vehicle delivery only after complete payment. So here, as per this agreement, which you had at page
Yes.
17, vehicle
Yes.
delivery only after complete payment.
Yes.
So
Yes.
this is an agreement.
Vehicle delivery only after complete payment. Yes, this was the first. He made an amount of rupees 10,000 booking amount. 10,000 he paid.
Now, what do you want?
Now I want that. Sorry, Mal.
What do you want from this court?
Lordship will kindly put this notice that this
Are you not challenging the FIR, Mr.? Are you not challenging the FIR?
to now. This way then issue a notice to the case that can come to the appropriate Mr. Rajit. I am not getting a copy of.
No, Mr. Mohanto, are you not challenging the FIR?
Malak,
Why you are not?
FIR not challenging here. The FIR I am not challenging because FIR has not been registered as yet. No police station case number is there. It is only a GD entry.
GD entry also, you see what is there. Kindly see this.
In the narrations on the notice.
So are you not challenging the GD entry?
GD entry I am challenging. GD entry, even if made, that this gives an information, they can make an inquiry, they can look into the facts. And then forward the zero FIR to the appropriate authority, appropriate police station for registration under 175, 174, 175 BNSSS. Therefore, the mere GD entry will not give them anything, but then notice to issue, he will have to have jurisdiction. When he asks a person which is beyond his jurisdiction, beyond the territorial limit of that police station, he cannot investigate beyond his jurisdiction. He cannot issue that notice. That is my case.
But otherwise, you see, from the very agreement you had,
Yes.
unless you complete the payment, the
Yes.
question is 17.
Yes, madam.
Unless you complete the payment,
Yes.
There is no question of delivery.
No, delivery. There is no question of delivery.
And
And
money which is being paid be forfeited.
forfeited. Even then, I returned some money. My lord, he failed to pay, and he asked here. He came here, asked me to pay. I returned some money. I paid some money. I have returned, and said that some amount I cannot because meanwhile that has been spent, given to the other persons. Therefore, he threatened me over phone also.
This happened in 2020,
Yes,
and the FIR is filed on 2025.
25,
So
2025.
why you are not challenging all these things?
But at the moment, I am not challenging because the FIR, I could not lay hand on it.
Or Mr. Mohanto thinks that this court is only into civil bench 1 or bench 4, 5. So may not know much into this.
No, my lord, no, not at all. I am grateful, my lord, lordship. One who is thorough there in that line, he is always thorough in other lines also.
Because
My lord,
otherwise there is no case made out at all.
no, my lord, my case is that FIR I can
I'm
challenge.
saying there's no case made out in the FIR.
Then, of course, I have a case for quashing.
It's a case
I
for
have,
quashing.
I have a case for
Pure and
quashing.
simple case for quashing. Because
Yes,
he himself says that he did not pay.
yes,
The question of he himself stating that amount only paid is to the effect of he has paid 17 lakh, 15 lakhs, 10,000,
yes.
so 24 lakhs. So therefore, there is no case made out in view of that agreement entered into.
Exactly, and no criminality at all. No criminal case. But this ought to have been looked into by the police officer before whom this was filed, and he ought to have refused it, or that he should have referred it back to the appropriate police station. That is my simple case now before your lords. He could not have asked me to come there. I cannot ignore it all throughout. Therefore, I am before your lordship. This notice issued is without jurisdiction. Therefore, I am now coming against that notice.
But
Once it,
I give you an interim order, but challenge the FIR.
I am grateful, my lord. I am grateful. I realize it, my lord. I realize it. We'll have to procure it somehow.
Heard Mr. K.K. Mohanto, the learned senior counsel, assisted by so-and-so. Full stop. Mr. V.G. Momi appears on behalf of the respondent number 1 and 2. As regards to and accepts notice, extra copy of the writ petition of the instant writ petition be served upon Mr. V.G. Momi during the course of the day. As regards the respondent number 3, the petitioner is directed to take steps by way of registered as well as usual. Full stop. In addition to that, the petitioner is also directed to take effect steps by way of the still routed through the registry of this court and file an affidavit of service on or before the next day. Taragote issue notice making it returnable on 19th of May 2025. Mr. K.K. Mohanto, the learned senior counsel, submits that from a very perusal of the learned counsel submits that the impugned notice so issued by the inspector of police, by the respondent number 2, that is the officer in charge of East Police Station, Dimapur, is without any jurisdiction, taking into account that the entire agreement between the petitioner and the respondent number 3 took place at Gauhati. He further submits that the respondent number 3 is a resident of Karbi Anglong, and there was no occasion for the respondent number 3 to file an FIR before the East Police Station, Dimapur. Further to that, the learned senior counsel submits that from a perusal of the agreement entered into between the petitioner and the respondent number 3, it is seen that there was a agreement for supply of a 14-tire truck for a consideration of rupees 24 lakhs, out of which a booking amount of rupees 10 lakhs was paid.
10,000, my lord.
10,000 was
10,000.
full stop. It was also mentioned in the agreement that the next date of payment was on 18/12/2020, and the final payment was to be made on 30/12/2020. The learned counsel, senior counsel, further referring to the impugned notice dated, what is that date? 17/11/3. 11/3, na?
11-3.
11,3.
Submits that even assuming for argument's sake that the contents of the FIR to be true, no case can be made out against the petitioner on the basis that the agreements were entered into categorically mentioned that the vehicle delivery can only be made after complete payment. He further submitted that in the circumstance the complete payment was not made, the amount which was deposited would be forfeited. First of all, the learned senior counsel submits that without ascertaining all these aspects, the respondent number 2 had issued this notice under impugned notice under section 35(3) of the BNSS 2023. He further submitted that this is the filing of the FIR, that too after a period of 5 years, that and before the East Police Station, Dimapur, was a complete abuse of the process of law, and as such, it is a fit case for stay of the impugned notice dated 11/2025. This court, having heard the learned counsel, this court also heard Mr. V. Jimomi, the learned counsel, appearing on behalf of the respondent number 1 and 2. Yes, what do you have to say?
Lordship, this notice may be issued, Lordship, since
He submits that the learned counsel submits that notice may be issued at this stage so that he can obtain proper instructions on or before the next date. First, this court, having taken into consideration the contents of the impugned notice and the respective submissions and the submissions made by the parties, including the contents of the notice as well as the respective submissions made by the parties, and also the agreements so entered into by and between the petitioner and the respondent number 3, is of the opinion that the initiation of the proceedings against the petitioner by filing an FIR dated 21/1/2025 is on the face of it an abuse. It prima facie appears to be an abuse of the process of the court, process of law. Apart from that, this court finds no basis, even from a perusal of the impugned notice, as to how the East Police Station, Dimapur, Nagaland, has got the jurisdiction to take steps to issue the impugned notice. Because apart from that, it is a perusal of, give me the BNSS. Now it is 174, na?
Yes, 174.
174, I think 174(3), which says that if that court does not have the jurisdiction, then
Yes.
police station, it will be sent to here.
Yes, my lord. My lord, here what happened? That lordship will find in 175. 174 says, 174, one lordship will kindly peruse.
Now 173, information
Yes.
cognizable offense, orally reduced in writing, so and so provided, so and so.
Yes.
Copy without prejudice to one side a receipt of the information, any person agree by the refusal on the part of human. Officer in charge of me with the prior permission of the human. It is outside the usual procedure here in the information of 175. 175, 170, yes.
What? 175? Please
So,
say it so.
the officer in charge of the police station without the officer. This court further finds it relevant to take note of section 175 of the Bharatiya Nagarik Suraksha Samhita 2023, which categorically stipulates that the jurisdiction of the officer in charge to investigate a cognizable offense which is within the jurisdiction of the court over the local area within the limits of such station, having the power to inquire and to try under the provisions of chapter 14. First, taking into account that it prima facie appears from a perusal of even the impugned notice that all the transactions happened outside the jurisdiction of the magistrate of the court to try, inquire and try under the provisions of chapter 14 of the BNSS 2023. It is the opinion of this prima facie, it is also the prima facie opinion of this court that the East Police Station, Dimapur, did not have the jurisdiction. Fusto. Accordingly, this court, for the interest of justice and to prevent interest of justice, stays the impugned notice dated 11/3/2025, issued by the Inspector of Police (UBI) Officer in Charge East Police Station Dimapur in connection with East Police Station GDE number 24/25, 2025, dated 21/1/2025 till the next date.
Deeply obliged.
Yes.
Deeply.
For motion from the supplementary cost list, item number 4.
Just 1 minute. Just 1 minute. Mr. Santianga and Mr. Moaimchen. Yesterday, I passed one order pertaining to that contempt. I think, Mr. Moaimchen, you need to file an application seeking extension in the writ petition. Because I don't know whether you have explained the gravity of that order if I would have passed. I have not signed that order. Because if moment I signed that order to the effect that there is a charge being framed, these two persons are rendered in the capacity of an accused. And then the further consequences will befall upon them.
Correct.
So I give you some time, but in the meantime, before I go, you file an application for extension and I'll pass an order. Before 11th, you immediately file an application. That day, one of your lawyer had passed a similar application, asking for some time, so I can pass an order. And the order which I propose to pass in that application, which is yet to be filed, is the effect of the regularization shall be given the effect to from the date on which you become complete 30 years. I think then your problem is also solved.
Much obliged.
If you Kali contempted, we'll have it on 11th, that contempt. In the meantime, you file this. Yes, what is this AB?
Your Lordship, this is an qualitative application, Your Lordship. FIR Annexer 1, Lordship, page number 14, Lordship. In this case, Lordship, informant stated that, Lordship, namely Akaitu Yaptu, Lordship, that I have given one JCP to him, Lordship, bearing registration number so and so on higher basis, Lordship. Accordingly, Lordship, he have paid to me, Lordship, 8 lakhs rupees. And thereafter, Lordship, the said vehicle has been seized by the district magistrate of Golaghat, and the same has been returned by the police personnel of Golaghat police station, Lordship. But Lordship, the remaining amount has not paid to him, Lordship. So that's it. Basically, Lordship, this is a civil dispute, Lordship. And it is absolutely right, Lordship.
When is the FIR filed? What is these sections 316 and what is 318?
316, Lordship, that is the 3162 and 318, Lordship, that is breach of touch, Lordship. 316 breach of touch, Lordship, and 318 is for Lordship. That is a shipping, Lordship.
Yeah, Sandeep, huh?
Breach of touch, Lordship, and another one is the sitting, Lordship. So this section is not effective in case of me, Your Lordship.
So 4318 is cheating now, 420.
Yes, Lordship. In para number 15 and 15A, I have categorically mentioned.
316.
Therefore, 316,
Breach
Lord,
of
that is
trust.
pertaining to the criminal breach of trust, wherein it is provided that whoever being in any manner entrusted with property or with any dominion of her property dishonestly, misappropriate or convert to his
When was
own
the
use.
FIR filed?
Lordship,
When was the FIR filed?
FIR filed in the year of 2024, Lordship. That is on 21/7/2024, Lordship.
Then
Until then, Lordship, no notice was served upon me, Lordship, by compliance to the statutory provision of BNSS Act 35, subclause 3, Lordship.
so
But
if,
very
if the police sends you a notice, you are going
Just I came to
you are
know,
going to fulfill it.
but just I came to know, Lordship, that 31st of March, Lordship, the police personnel of here, Lordship, another police personnel of concerned police station has searching after me, Lordship, but very fortunately I was not present there, Lordship. But the entire snake has been came upon me, Lordship, when I contacted to the lawyer, Lordship.
Madam, when can you get the CD?
Your Lordship, I think the CD has to come from Dimapur. It's in Dimapur police
Okay,
station.
we have it
Dimapur.
on, we have it on, today is 7 to 9, no? Let us have it on 2nd of May,
Second.
okay? And in the meantime, let him go and appear before the police station.
No
I give him an interim break. Let him appear before the police station on 22nd of April. No, Bihu, you don't like Bihu, I suppose.
Yes.
No Bihu. Okay, appear on 22nd of April. And on that date, you whatever questions are to be asked and produce the updated CD on the next date.
Could you the CD?
Huh?
CD.
CD on the updated CD after his appearance on
Okay.
22nd.
Okay.
Then we'll get some glimpse as to whether he's entitled to absolute bail. And this is an anticipatory.
Yes.
So I give him an interim, let him go and participate
Okay.
in the investigation. And
Okay.
then thereafter we'll look into it.
Yes, sir. Let him come personally appear on that day.
On
For the
22nd.
police.
But Lordship, one thing is that no issue, Lordship. I'm bound to appear before the concerned police station, Lordship. But what happened, Lordship? Actually, Lordship,
Mr. Counsel,
yes,
if you don't appear,
I'm
no,
willing to appear, Lordship.
no
But
arrest. I only issue notice, okay?
Lordship, direction may be
No,
given,
no,
Lordship.
we are
No,
only
only
issue
I'm
notice.
saying
No,
that,
no,
Lordship,
nothing
that-
doing.
That Lordship.
Oh, you
that
produce the
similar-
CD. You produce the
Your
CD
counsel,
on here.
only
No,
way
no,
I'm
no.
willing to pay, Lordship.
Then
I'm willing to appear before the concerned.
go and appear. That is what I'm giving you.
Yes, Lordship. I'm willing to appear.
Raho.
Interim protection will be.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Miss Livika, the learned PP. Today I was telling our brother, brother Justice Zamir,
Yes, Your Lordship.
that what is this type of PP is happening. So he said that I think he's taking out with the government,
Oh, Your Lordship.
the learned so-and-so PP, who appears for the respondent number 1, a respondent. This is an application filed under section 483 of the Bharatiya Nagarik Suraksha Sanhita 2023, seeking pre-arrest bail to the petitioner in connection with Dipu Pahar PS case number 41/2024, registered under section 316(2)/318(4) of the Bharatiya Nyaya Sanhita 2023. First, I have perused the FIR and taken note of the submissions made by the learned counsel appearing on behalf of the petitioner as well as the learned PP. Disco. এতিয়া সেইখিনি বাকিখিনি লিখি দিব and he is going to and this court directs for production of the CD on 2nd of May. It will লিখি দিব কেনেকে হয় আমাৰ ফরম্যাটটো আছে না, and he is going to appear before the police station officer, the investigating officer of Dipu Pahar PS case number so and so on 22nd of April 2024. And he shall not be that is one of the conditions. Condition of Friday. Interim to the
For admission.
And in the event of his arrest, he'll be given the 15,000. 15,000.
Eligibility order be furnished to me in the course of
Oh
the day.
yes, you take
Order of the court be furnished during the course of the day.
a copy of this week. What format to us, no?
For admission, item number 1.
Lordship, the respondent have filed a respective affidavit and I will receive this morning.
Yes. I've heard him. Now you tell me how were you appointed?
My lord, yes. My lord, here, the private respondent, he is the landowner. His family has donated the land for construction of GMS, Pilongri, under Gifri district. And thereafter, the GMS was upgraded in the year 2017 to government high school. After the upgradation of the school from middle school to high school, the school was shifted to a different site, to a new site. Yes, of course, the new site is donated by the village council of that very village, Pilongri village. But the land that the private respondent's family donated is still in use as a staff quarter, wherein the government high school staff, they are residing. So that is how I was appointed on land ownership basis. That is how I was appointed on land ownership basis.
No. For being appointed on land ownership basis, isn't there a requirement for a recommendation?
Yes, my lord. My lord, here in the present case, that the matter was referred to Deputy Commissioner. Deputy Commissioner has taken necessary recommendations and instructions.
Matter was not referred to here. The first and most important thing, his application went from a particular. You file an application.
Yes, my lord.
On being appointed on the basis of landowner or whatever may be. Once that application goes, it goes through a proper channel.
Yes.
In this channel, it was the recommendations were made that whatever may be, both of them cannot be appointed on landowner basis. This was the recommendation. Then why did the Deputy Commissioner appoint you on landowner basis?
My lord, I'll come to that. The Deputy Commissioner has set up a committee, and that committee has taken a decision that is in the writ petition. And that committee decided that came to a conclusion that the land where the present government high school is constructed is a land donated by the village council. And that the question of land ownership does not arise. That was the conclusion that Deputy Commissioner came to the conclusion. Thereafter, Your Honor, my Lord, I have written an application, re-appeal to that is it, page number 8 of my affidavit in opposition. I have written at page number 8, I have re-appealed to the Deputy Commissioner to reconsider my case. Because to reconsider my case and to do away with that earlier recommendation. Thereafter, since there was no positive response forthcoming, the private respondents through a legal counsel submitted a legal notice. That is it, page number 9 of my affidavit in opposition. And this legal notice was served to the government with a copy to the Deputy Commissioner. As such,
Now, kindly come to page 36. This is the order of a principal director to the commissioner and secretary to the government of Nagaland.
yes, my Lord.
Okay. Now, here it says, on the subject cited above and in reference to the, I have the honor to forward herewith 3 applications along with relevant enclosure for the post of Chokidar MTS at the government high school under the establishment of the district education officer, Khipri, Vaid Sri so Chokidar, who voluntarily retired.
Yes, my Lord.
One is the name of the petitioner.
Yes,
His qualification is class 12, isn't it?
yes, my Lord.
Number 2 is Yo, who is class 8. Number 3 is one L. Horiba, who is BA. It is to be mentioned that the cases are forwarded to the DC Khifri for clarification of land ownership, and the DC has subsequently replied by letter dated so-and-so, stating that the issue of land ownership does not arise.
Yes, my
Okay.
Lord.
The matter is endorsed to the government for necessary action. Now kindly see the next page. Kindly come to 84. Administrative approval for appointment of so-and-so. This is given by the Joint Secretary to the government. In inviting application and cited, the undersigned is hereby to convey the appointment of so-and-so under the establishment of so-and-so upon till date regularized by so-and-so and retired valuably. Formal appointment is to be issued from your end accordingly as per the format. The appointment is made on the basis of land ownership certificate certified by Phengru so-and-so. Now, how does
My
this
Lord,
change happen?
Yes, my Lord, there is a
after
subsequent
5th of
development.
May?
Subsequent development after this.
Yes.
That's what I'm, if your honor, if your lordship may kindly come to page 8 of my affidavit in opposition.
Affidavit
Page 8.
filed by the?
Respondent number 4. There is a subsequent development after this.
Yes. What is that?
Page 8. I have written to the Deputy Commissioner, Khifri Nagaland. Subject is re-appeal for together post at Philung GHS. With reference to the subject cited above, I have the honor to state that.
So now the Deputy Commissioner again writes another
Yes.
letter on 19th of June 2023.
Yes,
That is of page 12.
yes, my Lord.
In continuation of the letter dated demand, I am forward a copy of the application along with his enclosure received from Machang and so-and-so and received from Inti Longchar, advocate so-and-so in connection to appointment of Chokidar here. It has been mentioned that the matter may invite unnecessary distress and inconvenience in functioning of the school, and it will be difficult to acquire new land for further development if in future. Forward.
Here in my application to the Deputy Commissioner as well as in the legal notice, our stand was made very clear that
What is the
Uh,
legal notice?
I may be a legal notice is page number 9, starts from page number 9. I'm the sole landowner.
Allowed for establishment of the government middle school in Iman, the GMC was updated in 2000. Chokidar named this so-and-so. Then my client applied for a post on Iman appointed by various council. Land agreement dated so-and-so. Certificate so-and-so, so-and-so. Therefore, ignoring the client. 12th of May 2023. So on the basis of this letter, they have decided this.
Yes, your
The
lordship.
deputy commissioner, on the basis of this letter, forwarded to the principal director.
Yes,
And thereupon, the appointment has been given on 11th of December. That's it.
my lord.
Yes, government. Oh, you are there. Okay. Kindly explain your stand. This is an affidavit.
Correspondent number 1 to intruder.
You see, when I come here, things moves fast. Affidavit has been filed. Now what does the principal director do? I am only finding it difficult. This is the letter by the principal director.
Yes, Lord.
Okay, so here the principal director earlier says that there is no issue of land ownership.
Lordship, this principal director, he wrote this letter on the basis of a report submitted by the deputy commissioner.
Understood, everything else.
And
But
the
the
deputy
question is
commissioner.
now, therefore my question is, madam, what does the principal director do? You see, after all, there has to be something mentioned by the principal director because he himself says in a communication dated 12th of May. 12th of May, na?
Yes, Lordship. Oh,
Yes,
5 May.
5th of May. He says that all these things, what is happening out there is illegal, doesn't he? It has to be by landowner basis. Now what happened? There is a change in the stand by which the deputy commissioner and legal notice is being issued by advocate. After that, the deputy commissioner forwards it to the principal director. What does the principal director do?
Lordship, the deputy commissioner subsequent letter also, he has not recalled the earlier decision. In the subsequent letter, written by the deputy commissioner, here he has not recalled the earlier decision. The earlier report is at page number 54 in my writ petition.
No, madam, how do you take care of the principal director's letter of 5th of May? The deputy commissioner thereupon writes on 12th of May to the principal director after you issue a notice. At 12th of June, 19th
19th of
19th
June.
June.
19th of June.
19th of June. Now, what does the principal director do? That aspect is missing, madam, isn't it? That link is
Yes,
missing.
that is not there on record as of now. However, all these communications were communicated to the concerned authority, to the government, and as such, the government has decided to give land ownership appoint me on land ownership as one-time measure, because I'm the only land owner here. The private respondent's family is the only landowner here.
Lordship, the
And-
issue is,
and with the-
during the process of verification, the private respondent, he failed to produce new documents. That is recorded in the report. Lordship, on the page number 34 in my writ petition. Subsequently, from where he has brought another record, he needs to produce it to the deputy commissioner. That is the issue.
Mr. Counsel, I think you need to just bring on record that by filing an affidavit in reply. Bring that aspect. Because it would not be proper on my part to bring that. Bring the missing link.
Lordship, the missing link to the record is not with me. This was produced by the state government.
No, say that there is no missing link.
No.
You see,
After the
19th of June, the deputy commissioner writes to the principal director.
exactly.
Whether the principal director takes any steps, because without the recommendation made by the principal director, and the deputy commissioner does not say only refers on the basis of the said legal notice, but does not decide on the question that he is the owner. Isn't it?
Lordship, can I appreciate this? Page 34. It may read, please.
And that I've seen. Kindly see this Deputy Commissioner's letter.
Yes,
In
Lordship.
continuation of the letter dated so and so, I am to forward herewith an application along with its enclosure received from so and so, received from me, which is Selvi. In this regard, it may be mentioned that the matter may invite unnecessary distress and inconvenience in the functioning of the school, and it will be difficult to acquire new land for further development if it is in future.
If this is the case, in that case, he has to review the earlier decision. Earlier decision is not reviewed in this.
No, he has, let us assume that he has done so. Say that now, but there has to be a finding somewhere by the Deputy Commissioner that yes, the land belongs to him, that he is entitled to. He says out of fear. Isn't it, madam? Kindly come to page 12 of his affidavit. See the language. Isn't it out of fear? You have a copy? Oh, give it to him. Why haven't you given him? A person who is supporting you, you are not giving him.
No, Lordship, this later, the state government, they also annex as annexure 1 in their affidavit.
Page 12. See the fear. Although we take an oath without fear and favor. See the fear of the Deputy Commissioner.
In the affidavit, it's here. Please read.
In continuation of this letter dated so and so, I am forward herewith a copy of the application along with the enclosure received on from so and so, date and later dated so and so from so and so, in connection with appointment of Chokidar at so and so, which is self-explanatory. In this regard, it may be mentioned that a matter may invite unnecessary distress and inconvenience in functioning of the school, and it will be difficult to acquire new land for further. Isn't it required? What is enclosed stated means those documents. Now, therefore, isn't it required that if you are going to give on landowner basis, you have to come with a categorical statement, yes, he's entitled to on landowner basis. Where is that link? Where is those things which is not there, either in the 19th zone or subsequently by the principal director? Or if you have decided at the time under by issuance of the impugned communication dated, approval dated 11th of December 2023, where is your statement? That is the approval. Where is your statement in your affidavit to the effect that you have looked into and found out that he is a landowner?
In the paragraph 3, page number 3 in the state affidavit, in the sub-para, in the last 3 line. After reviewing all available reports, that is your statement. And considering the circumstances, the department decided to appoint so and so on the basis of payment.
Is that land where now the staff quarter is donated by him?
Your Lordship, you are claiming
Isn't
that.
it the finding of fact there, right? That by the authorities?
Lordship, that is a case during the process of inquiry. During the process of inquiry, he has to produce all that.
Mr. Lampang, the question is, why should this court enter into this aspect?
No,
If
Lordship,
the
as per the-
land-
as
if
per
the
the-
la- if the land in question has been donated, then
Lordship, as per the scheme framed by the state government, if there's a claim for appointment on the basis of rural agreement, verification has to be done by the office of the Deputy Commissioner of the concerned district. In compliance with this provision, verification was conducted. The verification committee gave a report against him.
no, verification as per the new, that policy will arise only in respect to what? Can you see the verification, this particular document? Categorically says that if it is earlier what?
Page 34.
You see, here the donation was given in 2020. Affidavit on land agreement staff quarter signed on 9/7/2020. So there is already this is in respect to those which have happened earlier. Kindly see. In fact, after 5/3/2018,
Yes, Lordship.
there cannot even be a land agreement.
Yes, Lordship.
My lord, the land was not donated in the year 2020, but land was donated in the year 1982. Land donation was done in 1982 when the first government middle school was opened. This 23/3/2020 is of recommendation.
Oh, Lordship, you are basing on a land agreement which is annexed at page number 12 and 13 in the state government affidavit.
Of the government.
Government affidavit. 12 and 13. Page number. Lordship, this agreement is totally in violation of the policy framed by the state government. You cannot rely on these documents. If the lane is required, it has to be clear.
Isn't it in violation of your policy?
Tell your-
Because this says that cannot be a land agreement entered into after 2018.
My lord, if I may, if I
Yeah,
can
please,
on.
please.
My lord, this is not an agreement. This is not an agreement.
Ah.
The word, it is very clear. This is not an agreement. This is just
Is a bona fide
recommendation.
citizen of
Recommendation
so-and-so
by the
and
village
donated
council.
free plot of land
This is
which have been
recommendation.
constructed for staff quarter for the school institution and so and so.
Therefore, the post of one grade 4 together is lying vacant.
No,
So
where is
then
it?
owner-
Where is it? Any document to show that in 1962 you had it?
My lord, this is a verbal agreement only.
The verbal, then if it is a verbal agreement, then you have to do a 3B.
Yes, it is approved by 3B.
It has to confirm with
As such,
3B.
the
Now,
deputy-
where is the finding of 3B?
As such, the deputy commissioner has verified.
Where?
Lordship,
There is no
3B
finding.
No, Lordship,
19th of June 2023 does not say anything about finding. It is the duty to do under 3B.
Lordship, the report under 3B is at page number 34.
After this page 34, brief report on the matters pertaining to appointment of Secretary Pelong GHS, this is page number 4 of the writ petition. After this, since it was decided against me, I have filed an application re-appealing to the deputy commissioner to reconsider my case.
No, Mr. Kishuk, I appreciate one thing. If you are basing upon a land agreement of 2020, it goes against the notification.
It's not on
No,
2020.
listen. If you are basing on the land agreement of 1962, then there is a requirement of a verification in terms of 3B. This verification report has to be there. Where is the verification report?
Should be page 34 in the writ petition. Para 3, it relates to the private respondent. The applicant of series so and so.
Was
the
applied
private
against the
respondent.
retirement of training on the Iman. However, no written agreement here. No, no written agreement. This is also wrong. This is also wrong. So if he had applied on the basis of oral agreement, this has to be done in terms with 3B by the Deputy Commissioner. He has not done that. So we need to do one thing. What is the course of action? This court needs to do now. Now tomorrow, if he has actually an agreement of 1962, then in that case, and there was something done, then in that case, the authorities, should we now disturb his appointment, or should we make it his appointment subject to the outcome of 3B? Because 3B has not been done.
Worship, I guess re-verification may be directed.
I think let us do one thing. We dispose of the instant petition with a direction without touching upon his appointment and saying his appointment shall be subject to a verification to be conducted in terms with 3B. And wherein you may be given an opportunity of hearing. You want to go there?
Yes, Worship.
Fair enough.
Then it is fair for
Fair
both.
enough.
Because I set him aside. And tomorrow actually,
Department may face some.
no, tomorrow if he actually is, then there will be a very long process again to be made.
Yes.
So it will have far-reaching consequences. So the best orders, I think, will be for all of you. Chalo, let me dictate. Mr. Limapong, the learned counsel appearing on behalf of the petitioner. Ms. S. Cheng appears on behalf of the official respondents. And Mr. Tikichu
Yes.
appears on behalf of the respondent number 4. By way of the present writ petition, the petitioner have assailed the approval,
Page 30.
administrative approval given by the Joint Secretary to the Government of Nagaland, Kohima, dated 11th of December 2023, for appointment of the petitioner, respondent number 4, on land ownership basis. First, the petitioner have also assailed that the subsequent notification dated 13/12/2023, whereby the Principal Director of the Directorate of School Education, Nagaland, Kohima, had issued the appointment order in favor of the respondent number 4 as a multitasking staff, (MTS) GR Roman 4 at GHS Pelungri under the establishment of the District Education Officer Khipri in under the Department of School Education. First of all, the merits in respect to the challenge so made by the petitioner can be ascertained on a perusal only upon a narration of the facts leading to the filing of the instant writ petition, which is narrated here infra. First, a post of Chokidar (MTS) a vacancy of Chokidar (MTS) arose under the establishment of the Government High School, Pelungre, due to the voluntary retirement of one Sri Thongkyung Sangtang. See the spelling properly at page 4. That is the father of the petitioner in the instant proceedings, with effect from 31/8/2000. The petitioner herein, with effect from 31/8/2019. The petitioner, who claims to be eligible, submitted his application for consideration of his case as an indigenous candidate of the said district. Full stop. Along with the petitioner, two other candidates also submitted their applications.
Yes, sir. Two others.
Two other candidates also submitted their applications. And one of which is the private respondent number 4. The application of the private respondent number 4 for being appointed to the vacant post is on the basis of land ownership, which is a policy of the state of Nagaland. On the basis of a notification issued on 5/3/2018. Full stop. The SDO bracket C HQ of the Office of the Deputy Commissioner Khifri, Nagaland, had submitted a communication on 19th of August 2020, wherein it was mentioned wherein the verification report on land ownership basis for appointment of the Chokidar at GAC Felungere was forwarded. In terms with the said verification report, don't write that SDO had forwarded that one. Anyway, the Deputy Commissioner, Khifri, by the communication dated 12/1/2023, forwarded a copy of the minutes of the meeting on the matter pertaining to the appointment of Chokidar at Felungre JHS to the Principal Director, Directorate of School Education, Nagaland. Full stop. The enclosure to the said communication is the report submitted by the Subdivisional Officer C HQ Khifri, Nagaland, wherein it was mentioned that the petitioner's application for the post of Chokidar at GHE Felungri was on the basis of the retirement of Sri Thongkuing Mong. Full stop. It was further mentioned that the application of the respondent number 4 for the post of Chokidar at GHE Felungri was on the basis of land ownership of the staff quarters located at the old school building, which is in use by the department. It was mentioned in the said report that there was no written agreement or terms and conditions with the government could not be produced. It was therefore mentioned that as the vacant land, the vacant post of Chokidar for the GHS school building falls under the community donated land, the issue of land ownership should not arise. On the basis thereof, it was mentioned that the application of both the applicants for the post of Chokidar be examined by the concerned department and appointment being given on the basis of merit and not on the basis of land ownership. Full stop. It is seen that thereupon the principal director, Directorate of School Education, Nagaland, Madam, wherever I'm mentioning the name, you see that it's the respondent, huh? Put the name, the respondent number 2 or whatever maybe. You just put it like this. And just for example, when I'm mentioning about the principal director, you say it to be the respondent number 2. And when I'm saying about the district commissioner is not a party.
Another party, Lordship.
Whom should I direct?
Lordship, as per the scheme, it has to be, the department has to forward to the
Who is
company,
going to make the verification?
Deputy Commissioner.
Then how do I issue a writ?
Lordship, that the principal director may be directed to forward the case to the Deputy Commissioner.
So deputy commissioner, you put it as deputy commissioner, he's not a party. District, the respondent number 2, basing upon the said report submitted by the subdivisional officer HQ, Khifri, the officer bracket C, HQ's Khifri, the respondent number 2 issued a communication to the respondent number 1. This is different. You are not making all these people a party. Issue the communication to the Commissioner and Secretary to the Government of Nagaland, Department of School Education and SCERT, whereby 3 names were forwarded. Full stop. It was categorically mentioned in the said communication dated 5/5/2023 that in view of the report submitted by the DC, the issue of land ownership does not arise. Full stop. However, pursuant thereto, on 11th of December 2023, the Joint Secretary to the Government of Nagaland conveyed the administrative approval for appointment of the respondent number 4 to the post of Chokidar/MTS at GHS Feluguri under the establishment of DEO Khifri, which is the subject matter of challenge in the instant proceedings. Subsequent thereto, the respondent number 4 was appointed by the respondent number 2 via the impugned notification dated 13/12/2023. Being aggrieved, the petitioner has approached this court on the ground that there is a violation to Article 14 and 16 of the Constitution, inasmuch as if the land ownership basis was not the issue, the respondent authorities could not have appointed the respondent number 4 could not have issued the administrative approval as well as the appointment order, which are impugned in the instant proceedings in favor of the respondent number 4. It is seen that pursuant to filing of the instant writ petition, notice was issued upon all the respondents. the record reveals that pursuant to an order passed by this court on 4/4/2025, both the state respondents as well as the private respondent have filed their respective affidavits. First, in the affidavit filed by the state respondent, it was mentioned that pursuant to the communication dated May 2023 by the respondent number 2 to the Commissioner and Secretary to the Government of Nagaland, Department of School Education and SCERT, the department received a forwarding letter dated 19/6/2023 from the Deputy Commissioner Khifri along with the enclosures. The enclosures so submitted were an appeal dated 12/5/2023 from the respondent number 4 requesting appointment to the post of Chokidar at GHS Pelugri. B. Application letter dated 23/3/2020 and 13/11/2022 from the Pelugri Village Council recommending the respondent number 4 for the post of Chokidar at GHC Pelugri based on land ownership. C. Affidavit on land agreement bracket staff quarter signed on 9/7/2020. D. Legal notice dated 26/5/2023 issued on behalf of the respondent number 4. It was further mentioned that the initial what is that? Government middle school?
Government high school.
No,
Middle school initially.
Initial government middle school at Pelungri was upgraded to government high school in the year 2017 and relocated to a new site. The land for this new location was donated by the Pelungri Village Council. The old school site is now used as staff quarter of GHC Pelungri, which the private respondent have donated which the private respondent have was the in respect to which the private respondent was the donor. It was also mentioned that in the legal notice dated 26/5/2023, the private respondent indicated an intent to vacate the land by removing the staff quarters of GHS Pelungri if he was not appointed to the post of Chokidar at GHC Pelungri. Therefore, it was therefore mentioned in the affidavit that considering all the available records, the department decided to appoint the respondent number 4. This court further takes note of that the affidavit filed by the respondent number, the private respondent, wherein the private respondent have also taken a similar stand which has been taken by the state respondent. First, this court heard the learned counsels appearing in the backdrop of the above. This court heard the learned counsels appearing on behalf of the parties. From the materials on record, it is seen that on the materials on record, it is seen that the government of Nagaland had issued a notification dated 5th of March 2018, thereby notifying a policy with regard to appointments to grade 4 posts under the government of Nagaland on land ownership basis. This court further finds it pertinent to take note of that a perusal of Clause 1A categorically stipulates that with effect from 26/7/2005, there cannot be any agreement entered into for for acquiring any land free of cost with a condition for employment in service or contractual works. This code further finds it relevant to take note of clause 3, 3A and 3B, which stipulates that in respect to cases prior to 26/7/2005, where a specific written agreement exists providing for employment to landowner, the claim of ownership for employment should be settled in terms with such agreement. It is further seen that if there is any claim for providing employment as a result of oral agreement, the department concerned shall refer the matter to the Deputy Commissioner of the concerned district, who shall examine such claim carefully, including whether any employment or any other facility, including contract or supply order, has been given in the past. First, the manner in which it is to be carried out is being specifically mandated in clause 3A of the notification dated 5/3/2018. First, in the instant case, it would be seen that in the instant case, it would be seen that the SDO CHQ had prepared a brief report on the matter pertaining to the appointment of Chokidar at Thulengri GHS. The claim of the respondent number 4 was rejected merely on the ground that there was no written agreement or terms and conditions with the government could be produced. However, without taking into consideration clause 3B of the notification dated 5/3/2018. This report, which was being submitted, this report was the basis on which the principal director had issued a communication on 5/5/2023 to the Commissioner and Secretary to the Government of Nagaland Department of School Education and SCERT. It is further seen that thereupon an appeal was filed by the respondent number 4 along with various documents. First, the record further reveals that the Deputy Commissioner, who ought to have thereupon made further verification and submitted a fresh report, did not do so, but only submitted a communication dated 19/6/2023, stating inter alia that the documents which were submitted by the respondent number 4, along with the legal notice, was self-explanatory. On the basis thereof, the impugned approval letter was issued as well as the impugned appointment order was also issued. This court, from the materials on record, and more particularly from the affidavit filed by the state respondent, it reveals that they have reviewed the materials, and on the basis of which the impugned order of on the basis of which the respondent number 4 was appointed on land ownership basis. However, there is no materials whatsoever have been placed as to whether the principal director, on the basis of the said documents, have asked the Deputy Commissioner to make a re-verification, and on the basis of which the Deputy Commissioner had submitted a report which is the mandate in terms with clause 3B of the notification dated 5/3/2018. First, taking into account the above, it appears that there has been some laxity on the part of the state respondents in taking due steps for the purpose of appointment of the respondent number 4. Under such circumstances, it is the opinion of this court that interest of justice would be met by directing the principal director, the respondent number 2, to seek an opinion from, to seek a report from the Deputy Commissioner, Khifri, in terms with clause 3B of the notification dated 5/3/2018, and basing upon the said report to take appropriate steps for the purpose of appropriate steps as regards the impugned approval order, as impugned appointment order of the respondent number 4. This court have given an anxious consideration in respect to the challenge to the impugned administrative approval as well as the impugned or notification by which the respondent number 4 was appointed, and taking into account that it was on account of the fault of the respondents for not taking appropriate steps, this court have not interfered with the appointment of the respondent number 4, but have made the appointment of the respondent number 4 subject to the outcome of the report to be submitted by so and so. Accordingly, the instant petition stands disposed of with the following observations and directions. The respondent number 2 is directed forthwith to take steps to seek a report from and take steps, and not later than 10 days from the date a certified copy of the instant judgment is placed before him for seeking a report from the Deputy Commissioner in terms with section clause 3B of the notification dated 5/3/2018. The Deputy Commissioner shall, in the procedure mandated under clause 3B of the notification dated 5/3/2018, make a determination as to whether the respondent number 4 is entitled to be considered on the basis of the land ownership basis. Prior to this court further directs the Deputy Commissioner to give a chance of hearing to the petitioner, who also claims right to be appointed at the time of deciding. But what right do you have? No right.
Against the resultant vacancy, I can apply.
Huh?
Against the resultant vacancy, I can apply my candidature. That is my only right.
No, that is okay, but against it, I don't think you have
No,
a
no.
right in that 5/3. Yeah, not right. That don't give it. Full stop. The report be submitted by the Deputy Commissioner within 3 months from the date it is being referred by the Principal Director, by the respondent number 2, Deputy Commissioner of Khifri and all. The report be submitted to the Principal Director so and so within 3 months from the date it is being referred by the Principal Director to the Deputy Commissioner. The Deputy Commissioner, however, also shall keep in mind that in terms with the notification dated 5/3/2018, there can be no agreement entered with the department on or after 26/7/2005 for acquisition of land with a condition for employment in service or contractual work should be entertained. Full stop. With the above the instant petitions.
For hearing, item number 2.
Yes, what is this?
Right, Mr. Lordship.
Mr. Jameel, I will take your matter later on. First, let me take her matter, because that matter has been just prolonging every time.
Yes, my lord. Here I am challenging the order dated 28/8/2017 passed by the District and Session Judge Dimapur, my lord. Worship, here I was sentenced to undergo 7 years rigorous imprisonment for offences under 326 IPC and 4 years under section 452 IPC. And the sentence.
Where is the
Just
issue
to-
order?
Sentencing order is at page 51, my lord.
We are on bail. No.
No, my lord, I have been inside since the day of my arrest.
7 years is over.
Yes, my lord.
Then what
He
remains?
was.
You've
No,
not been
lordship,
released.
7 years and 4 years under 452 IPC, the sentences to run consecutively, my lord.
No discussion of the evidence, nothing.
My conviction was solely based on
Huh?
the plea of guilt, my lord. My conviction was solely based only on the plea of guilt, my lord. There was
Only
no
on the
trial.
basis of?
On my plea of guilt, my lord.
Where is it?
Worship, my,
Confessional statement.
yes, my lord. The
That is before the
confessions-
judicial magistrate.
Yes, my lord.
And no, in before the court.
No, my lord. Worship,
Where is the records?
Worship, I was not provided with any of the orders of the trial court, my lord.
What is the name of the person?
Lordship, it's Dorjan Mirtha. Of Rakesh Mirtha.
And what is this particular person? This accused
Yes,
who
my
has
lord.
been convicted.
Yes, my lord.
What did he do?
Lordship, he was convicted.
No. That I know. What does he do otherwise?
Lordship, he is an illiterate, my lord. He was, in fact, he was working as a helper in that house where he went to that night, my lord.
And was he represented in the court
Yes, my lord.
by a
He
lawyer?
was by a legal aid counsel, my lord. In the trial court also, he was assigned a legal aid counsel, my lord. And in fact, I am also a legal aid counsel, my lord. It's sent to me by the legal aid authority, my lord. And since he doesn't have the financial aid and
These are statements who has recorded. What is the recording in the court? Court has not recorded any evidence.
Lordship, I also have doesn't have those records, my lord. I was not provided with any of the court records, my lord.
Into murder. Who's the person? Issue so. Memorandum of inquiry.
Lordship, there is a copy of the deposition in at page 43 of my petition.
Final information. Sheet. Maintenance statement. These statements which are there from 74 onwards, these are 164 statements, I suppose.
Yes, Lord. Page 30, from page 38 is the convention,
From
confessional
page
statement.
74 onwards, these are all 164 statements
Page, my lord, page,
of the records.
Lordship, I don't have the records. with me.
What were you doing?
Lordship, I was only provided with these documents, my lord, by the legal aid authority.
Of course. If you understand that you- Where is the pleading guilty? Nothing is there. How does he plead guilty? There has to be something. There is no record of anything. My goodness. Mr. C.T. Jamir, you are a senior counsel. Therefore, it is required by the legal aid clinic which we are having now. This is the most pertinent. Earlier also, we found another case. Where is the judgment? Me and Justice Chaudhary. Here, these persons, they are not being told what is the effect of are pleading guilty. Nothing is there. There is no other evidence taken, na? I don't see the evidence of any of this, even the evidence of this police officer being taken. How is it possible? Isn't it the law that the charge will be framed after initial deposition, after the prosecution evidence? Nothing is there. Goodness.
Court officer, Lordship, since conviction was issued by the lower court in view of the confessional statement of the accused.
No.
Lordship. So, Lordship.
No. Confessional statement, when do you record? You see, on the basis of confessional statement also,
Lordship.
I will not require, isn't it the confessional statement, the document and evidence? Okay.
No.
Now, initial, whatever he may say, isn't it required for the prosecution to place his case by his evidence that this happened? This person have done this.
Lordship. Lordship.
He have said many things, that is a different thing. But
Okay.
confessional statement is always taken a very weak piece of evidence. Isn't it the law? The confessional statement,
So, Lordship, since the imprisonment is for 7 years, Lordship, so
huh?
if the imprisonment is for 7 years, Lordship, the conviction is for 7 years, Lordship, is
7+4.
7 plus 4, Lordship. So if the matter can be reverted to the lower court for proper trial, Lordship.
Absolutely no. This is not a case for again. How many years will he go down? Huh? Hello, you should have a bit, Mr. Jimomi. This is not done. I don't expect this type of things. Arguments out there. How can it, somebody may say anything to that effect? No evidence, nothing. $29 feet, 2017, let us see those. You see this, the best part. The learned so-and-so is present, heard so-and-so present, the accused so-and-so is in jail. Charge framed against, explained, and here be understand, and he understand, and to when he plead guilty and prayed for mercy. This can be, the case can be fixed for examination of the complainant as so-and-so prayed for Iman, issue summons to the complainant, number 1. Okay? The accused so-and-so is produced to a PW1 not appeared, issue summon against the PW1. The learned PP so-and-so present and submitted that on the basis of the plea of guilt, the accused be convicted. Yeah.
Yes.
What thing? If this was not in India, if it was somewhere else, this is a case of huge compensation to the petitioner. And I am sorry that after admitting the revision in the year, I was the first one. No?
Worship, it was. Yes, my lord, 30/11/22.
6/4/2022. So liberty was given to file appropriate application for bail. You didn't file. It's still inside. Now, heard Ms. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. V.G. Mumi, the learned PP. The present revision application is directed against the judgment and ordered the judgment dated 28/8/2017 passed by the learned principal district and session judge Dimapur, Nagaland in ZR case number 1003/2016, by which the petitioner was sentenced to undergo undergo 7 years rigorous imprisonment for offense made out under Section 326 of the Indian Penal Code, bracket IPC, and to undergo 4 years under Section 452 of the IPC. It was also directed that both the sentences shall run consecutively. First, the facts of the instant case, as would appear from the materials on record, is that on 28/10/2016, at about 2:30 a.m., the petitioner herein allegedly entered the house of his previous landlord in order to demand money, and he was broke and unable to pay the rent. It was also alleged that the petitioner was serving in the house of the complainant about 10 years 10 years. From his age of 10, from the age he was 10, and had left their house after he got married. It was also alleged that the petitioner went to the house at 2:30 a.m. on 28/10/2016, equipped with a naga dao, knife, wrench, and a rope. The petitioner went on the top of the roof, removed tin roof,
The
alleged that
he entered the house through the roof, my lord. Top roof.
they will get something on the facts. Judgment is horribly drafted. With naga, dao, knife, wrench, and a rope. Stop. The petitioner, it was also alleged that the petitioner entered the house of the complainant through the roof. Stop. And while going through the passage, one maidservant by the name of Rama Kosari saw the petitioner and screamed. So he hit her on the head with a dao. And again he attacked one Mary Konyak, a maid servant of 13 years of age. Thereupon the petitioner saw the owner of the house, Mrs. Atula Jamil, and was scared she would recognize him, though his face was covered. He ran away under the cover of darkness. It was also alleged that the petitioner did not stay in Nagaland and he took shelter at Duapathar village under Golaghat, Assam. Subsequent to the incident, an FIR was lodged
Where is that page 16? 28.
before the East Police Station, which was registered and numbered as DMR. DMR means Dimapur.
Yes, sir.
Dimapur East PS case number 321/2016 under section 450/452/352/307/326 IPC. Footstep. The petitioner was arrested with the help of Borpotha police and brought to Nagaland. Footstep. During the interrogation of the petitioner, he pleaded guilty of the offense, and accordingly he was charged, and accordingly a charge sheet was submitted. on 15/11/2016, bearing charge sheet number 236/2016. Under sections 450/452/352/307/326 Indian Penal Code against the petitioner. Full. It is further seen from the records that during the investigation, the petitioner's statements, confessional statements were recorded under section 164. By the
Judicial Magistrate, First Class, Dimapur.
how is this a confessional statement also? Recorded by the, who has recorded it? By the
Judicial
Judicial
Magistrate,
Magistrate First Class, Dimapur, on 15/11/2016. Full stop. The record further reveals that after the charge sheet was filed, submitted, before the court of which one? They don't put a seal signature. Before the court of the CGM, Dimapur, comma. The case was committed to the Court of the Sessions by an order dated 24/1/2017 by the Court of the Chief Judicial Magistrate, Dimapur. Full stop. The record further reveals that on 29/3/2017, charges were framed against the petitioner under section 450, 452, 307, 352, 326. And the petitioner had pleaded guilty and prayed for mercy. Full stop. The Court of the Sessions, the learned court of District and Sessions Judge Dimapur, hereinafter referred to as the learned trial court, thereupon fixed the matter for examination of the complainant. Full stop. However, without examining the complainant or even any evidence being taken, evidence being submitted by the prosecution, by the impugned judgment dated 28/8/2017, the petitioner was convicted under section
326.
326 for a period of 7 years, rigorous imprisonment, and under section 452 for 4 years. And both the sentences were directed to run consecutively. It is under such circumstances the present appeal has been filed. Full stop. This court have heard the learned counsel appearing on behalf of the petitioner as well as the learned Miss So-and-so, the learned counsel for the petitioner, as well as Mr. V. Jimomi, the learned counsel appearing on behalf of the respondents, and have perused the materials on record. Full stop. From a perusal of the records, this as well as the manner in which the judgment was pronounced by the learned trial court, it shocks the conscience of this court as to how the learned trial court have exercised his jurisdiction. Full stop. There is no prosecution evidence being laid before the court. Full stop. Merely on the basis of pleading guilty, the learned trial court had convicted the petitioner. Full stop. This court is further shocked and surprised to observe that how the charges were all framed even without any prosecution evidence being laid, which is a fundamental aspect in criminal trial. Full stop. This court further finds it relevant to take note of that the law is very clear in respect to section 228 and 229. The law is very clear in respect to section 229 of the Code of Criminal Procedure 1973 as to how a plea of guilty is to be recorded and what are the measures required to be taken by the court, and more particularly when the accused is an illiterate and belonging to a poor strata in the strata of the society. Full stop. The law, full stop. In the case of Limatosi versus State of Nagaland, the division bench of this court dealt with this said aspect of the matter in detail. Full stop. Limatosi versus State of Nagaland reported in
2022 2 JLT 7079.
2022
22
2 GLT 707 dealt with the aspect as to how as to what procedure is required to be followed when a plea of guilt is entered into. Plea of guilty is entered into. First, paragraph number 14 to 18 of the said judgment, 19 of the said judgment being relevant is reproduced hereunder. First, from the above quoted paragraphs, it would therefore be seen that when a conviction of an accused is based entirely on his plea of guilt, the court must take care to ensure that the plea of the guilty is voluntary, clear, and unambiguous. It is also required that the accused be clarified. It is also required that the accused be clarified and made to understand the nature of the allegations made against him. And the accused must admit all such facts which are necessary and essential to constitute the offense. It is the opinion of this court that in order that the court have to place these relevant facts, there has to be the prosecution evidence laid, the bare minimum prosecution evidence laid to constitute the offenses alleged against the accused. Full-stop. The law, as settled by the division bench of this court, makes it very clear that while convicting a person taking recourse to the provisions of section 299 of the code of civil, it was code, the court must have before it all such facts which are essential to constitute the offense, and such facts must be admitted by the accused before plea of guilty on the accused is acted upon. Full stop. It is also relevant to take note of that the learned division bench have also observed that when the accused pleads guilty, the court has also to it is also relevant to take note of that while examining the plea of guilty, the court has also to understand, the court has also to explain in clear and unambiguous terms to the accused, more so when an accused is an illiterate and belongs to the poor strata of the society, which is the case in the present proceedings. First, taking into account the manner in which the impugned judgment and award judgment was passed by the learned trial court dated 28/8/2017, this is not a case that the said impugned judgment cannot be sustained in law, for which this court sets aside the said judgment. Footstep. The learned counsel appearing on behalf of the learned PP, Mr. V. Jimomi, learned submits that taking into account that the evidence have not been properly taken, and there has been also certain inadequacies have not been taken, and there has been the evidence submits that taking into account that there were certain procedural defects committed by the learned trial court while passing the impugned judgment, this court may remand the instant case back to the learned trial court. This court had given an anxious consideration to the said aspect, and taking into account that the petitioner has been in custody since 2016,
16, my lord.
15/1/2016. What is the date when he was arrested?
18/11/2016.
On 18/11
8/11/2016.
2016. And almost how much? 6, 4, 4 plus 5, 9. 9 years have almost 9 years have passed by. This court is not inclined to remand the matter back to the learned trial court for a fresh adjudication to continue continue with the agony which has already been faced by the accused by the petitioner. on account of a wrongful conviction made by the learned trial court. Full stop. Accordingly, this court directs that the petitioner be forthwith released from the jail, and the registry is directed to immediately issue the order of release, warrant of release, or whatever may be. To মই সেইদিনা এটা judgment এটা দিছিলো মিজোৰামত চাই ল'ব, and communicated to the jail authorities so that the petitioner is forthwith released.
Much obliged, madam.
I don't take up criminal matters, so exactly what is the word used, I don't know much.
I'm highly obliged, madam.
Huh? So that is why return the LC. But this is a very sad thing.
For hearing, item number 2.
Oh yes, definitely. And it's a line, you are legal aid, na? Okay. So and so this court expresses its gratitude to Miss So and so, who acting as a legal aid counsel, has brought the above transgressions to the attention of this court.
Obliged.
Yes, Mr. Siti Zamir, your matter.
Lordship is well aware that under Article 275, Clause 1, there is a provision of granting central aid to the states in order to uplift the welfare of the scheduled tribe communities. So this is a beneficiary link scheme and a project. And under proviso to Article
This has to be clear.
275(1), the central government, the Ministry of Tribal Affairs, has framed the guidelines how to implement the different projects allotted to the states. In this connection, for the state of Nagaland, the guideline has been framed by the Ministry of Tribal Affairs, and then the projects have been selected for 2023-2024.
So you are challenging some letter dated 12/10/2023, 8/2/2024, and the meeting minutes. Let's have a look at annexure E, F, E, I, and J.
Before that,
What you are challenging
little
letter.
background will be required. After selection of the project by the state level executive committee, which will be sent as per the guidelines to the project approval committee, that has been done. Thereafter, the fund will come from the center. And then thereafter, the entire process will start. So when the fund has been received by the state, after receiving the fund, the Chief Minister has written a DO letter to the ministry.
Annexure E is
That is
annexure E is what?
Page 53, Lordship.
Okay, page 53 is what? This is a letter by the Chief Minister.
Yes. Basing on this, the ministry has given direction to the
change fishing in serial number under the infrastructure and priority list of project proposals and the articles were submitted by you for funding to change in the venue project from construction of a multi-purpose building at NH Iman to Chappa village. While I understand that the construction of the multi-purpose building at NH Village has been planned, recent developments have necessitated an evaluation of it. Immense potential would greatly benefit for the project being shifted to their location. Moreover, Chapka village currently lacks some center. So some community multipurpose building was to be constructed in Monastery,
Monsignor Yamti. It was
Monseni Unti.
Same
Now,
location.
now the chief minister wants it in the Chapka village.
Yes,
Chakpa.
yes.
Okay, now this is the thing.
The
Now, what
reason-
has happened? What happened to this request?
The reason given is.
You are for the Monicity.
Monsignor Yamti.
Ah, then why will we should go so far to 275? You are for this monicity, you don't want this multi-purpose building to be shifted anywhere else.
Because if
It is required for you.
it is required, then it has to be done in accordance with law.
Okay.
And
plan
in order
works
to implement the
under
scheme
270 as mentioned.
the
is
guidelines
adopted
have
to
been framed
bring beneficiaries.
by the Ministry of Tribal Affairs, in violation of those guidelines, the decision has been taken.
Okay, so the decision has been
skip.
taken, then.
And the
you are
reason given in the Chief
challenging
Minister's
I.
letter is.
Then the ministry changes it.
Yes, ma'am.
Changes it from purpose of the state government regarding change of the projection from multi so and so to Chapka village under Mukukso to has been agreed to by the company in the ministry subject to approval of the so and so so and so. I kindly share the complaint. So this has been agreed.
Yes,
Then the state level committee has also recommended.
yes, ma'am.
So you are the challenging this tree.
Yes, because without any DPR, the decision to change the location has been taken. And it started with the Chief Minister's letter, where the reason given was there is some recent development. So recent development when he wrote the letter was only to my mind, which comes to my mind is there was election in January 2023.
Oh.
That is the only development that
And-
has
and-
occurred
And your
after
constituency,
the project has been approved.
Mr. Jami, your constituency does not support the CM?
It is within the same constituency, but then the place has been changed to another village.
But don't you think it is the executive who has a better knowledge than us?
Lordship, I also agree with what the Lordship is saying. It is the prerogative of the executives for changing any policy decision. Now, for implementation of this project, the guidelines have been issued by the Ministry of Tribal Affairs under proviso to Article 275, Clause 1. There, the guideline given is the state level executive committee will examine. This is headed by the Chief Secretary. And then they will, first, before that, Lordship is well aware how a project is prepared, how the scheme is prepared. Concept note will start with the concept note. In the concept note, everything is mentioned, why this project is necessary in that particular location, how it should be, all these are specified in the concept note. That will be examined again, and detailed project report is being prepared, which has been done in respect of the Mongsiamti village. Now, after the state level executive committee scrutinizing all this, it will be sent to the ministry. That is Project Approval Committee, PAC in short. PAC will also examine and they will take a decision whether the SNEC recommendation should be approved or not. Once the PAC approves the same, sanction will be issued. That sanction is against that particular project for which all survey, everything has been done. After the fund is received from the center, then the process will start. The deputy commissioner will verify the land location. Everything will be done. That has been done. And this is a peculiar policy because unlike other policies, other schemes, here there is no provision of fund for purchasing land or providing land compensation. So the person who donates the land, they are the beneficiaries. Not necessarily that very person will execute the work.
Hmm.
The beneficiary will recommend a firm
Now, who are you?
against the land.
Why are you, why
I
are
have donated the land.
Huh?
I have donated the land for the project.
And what is you have
And-
donated the land. Why do you want this project in yours?
Because the government wants to set up the project in my land.
So
So
do you-
NOC was
do you
given-
gain?
NOC was given by the village council.
Now, how do you gain?
This is for the welfare of, this is a welfare project for the
Well,
development
isn't
and
it a
upliftment
public
of the
interest
scheduled
litigation?
tribe.
Wouldn't it be a public interest litigation?
Lordship, may kindly come to the concept note.
Yeah.
Why it is selected and why it is necessary to be located in that particular place. So it will be relevant, Lordship.
No, first of all, Lucas,
That's why, Lordship.
first
It is, I'm the beneficiary. Can you come to page 29, Lordship?
How are you the beneficiary?
Yes. This is the concept, not Lordship. Why it has been proposed. But Lordship here, when I was preparing for the hearing of this matter, I have discovered that we have enclosed the first page and the last page, and in the middle, inadvertently, one page which is very, very vital and important has been left out, Lordship.
Where? Concept. note.
Where
That is page number 2,
yes,
necessity of the project.
correct, Lordship.
That is not there.
Project approval committee decides based on the concept note.
Yes, what is your stance state? Why do you want to do it in Chappa?
My lord, the facts of the case in brief is that I've categorically stated in my affidavit in opposition from para 4 to 9. If I may be allowed to read my lord.
I'll buy respond number 1.
I'm for state respondents, 2 and 3. For the state respondents.
Who is for? What are you doing here?
Lordship, I am the village council, the
New.
multi-purpose building is proposed to be shifted from his village to my village, Lordship.
Now the building has gone. Builded.
No, no,
No,
Lordship.
not yet.
Nothing
They
has
just
happened.
stay.
Yes, Lordship.
Neither to the petitioner nor to the new
Yes. It is,
relocated
it has been made subject to the.
No such- work order has been issued till today. If I may be allowed to read my lord, running page, para 4 to following of my affidavit in opposition, my lord. That with regard to the statements made in para 2, 3, 4, and 5 of the writ petition is borne out of record. The deponent, however, begs to state that the Article 275, Clause 1 of the Constitution of India prescribes to provide grants in aid to the scheduled tribe across the country from the Consolidated Fund of India for the purpose of promoting welfare of the state scheduled tribes. It is admitted, borne by the records, that the Ministry of Tribal Affairs held the meeting of the Project Appraisal Committee with the government of Nagaland on 28 August 2023 through video conferencing and the proposal for construction of multipurpose building slash hall at Mungsemti village, and thereafter the MOTA confirmed the said project by communication letter dated 6/9/2023, annexure C and T of the writ petition.
Earlier, there was, kindly come to paragraph 5,
Yes,
So-
my lord, already constructed.
with the tribal affairs.
Yes, my lord.
With the tribal affairs, this is a community hall. And the present one is a multi-purpose,
Same, my lord.
So
Within the same village.
multi-purpose building.
that village, you don't like it.
Now, Lordship,
No, Mr. Dame, this is not a case.
And if I may be allowed to,
This is not a case, Mr. Dame. Why should we interfere 226? Unless there is something very illegal out there, you already have a multi-purpose.
yes, my lord.
This is
No,
for
no.
the state.
earlier, which was allotted, that was
No, under the tribal
Community
affairs,
hall.
under the tribal affairs, community hall, whatever maybe, you have something.
Yes,
The state will take up, next time they will give it to
yes,
you.
my, yes, my.
But first of all, this village doesn't have anything.
No.
So what is
true.
wrong with
Yes,
it?
ma'am. And the completion
You see,
certificate.
Mr. Jami, our hands are tied. We cannot interfere unless you show there is some
Sure.
arbitrariness.
I'm questioning the decision-making process of the authorities. Fund has already released by the center, basing on the project which has been prepared in respect of Mongsimdi village.
Understood. But now
Then-
the center, on the basis of taking into account the other materials which have been placed by the CM, have already taken a decision. No, now we are shifting it to this Chapka village.
Yes,
We are,
For this court, to interfere there will be very, very difficult.
the Lordship, the ground-up challenge is the Ministry of Tribal Affairs has issued a guideline how to implement. The approval which has been made by the project approval committee has been done. They are not ordinary persons. State level executive committee has examined thoroughly. After analyzing all this, they have taken a decision and it was placed to the ministry, project approval committee. Project approval committee has examined all these project reports and thereafter taken a decision, Lordship.
Understood.
A
Then
conscious
are
decision.
you saying that subsequently after the CM has written the letter, they have not taken into consideration the relevant aspects?
Yes,
Are you saying that they have not considered into the
first,
relevant
they
aspects?
should have complied with paragraph 8 and 9 of the guidelines. Because Lordship, can we come to the guidelines? I will just refer to the relevant portion, page 15 of the writ petition. This is issued by the Government of India, Ministry of Tribal Affairs.
Submission of the proposal.
Guidelines proviso to Article 275, Clause 1 of the Constitution of India. This was prepared in April 2020. And then can we come to page 21? 20, paragraph 8. Submission of proposal to Ministry of Tribal Affairs by the states. 8, Clause A. I will just refer to the relevant provisions, Lordship. Proposal shall be approved by the executive committee in the state concerned, chaired by the chief secretary of the state.
And
Before
Mr.
setting-
Jami, tell me, how many years, how many years these proposals are being given?
Every year.
Then why are you stalling their paying? This amount will lapse. You go ahead with a few fresh one.
They can also apply.
No, they can apply.
But
No,
without
why you are
applying.
into this? No,
Without
no.
applying, when all the process have been,
I think this is a
completed.
fit case for dismissal with cost. Absolutely no. One has to understand Nagaland doesn't have money.
true, my.
Some money, if it is gone and
Yes, ma'am.
something is done, let it be done. You apply for the second one. You want a multipurpose, have it.
no, Lordship.
You
That
have
is
already got one.
Yes, ma'am.
That is a community hall.
Whatever may be, next time you get another one.
Yes.
But
There are-
why you are stopping? This is a serious aspect where a fund of a state of the central will lapse, and it is must have lapsed because of this litigation. This is
No, no,
not the
if we
case.
feel that
Mr.
JAPA is the
Teme,
appropriate
This
place,
is,
they should have,
this is a very serious case which we have done.
I'm trying to show from the guidelines, Lordship.
If my lord may come to my affidavit in opposition, running page 10A, that is the completion certificate.
And more particularly when the coordinate bench have already passed a detailed order, not a case. I'm coming back in 5 minutes. Think about how much cost we can impose. Something and not should not be. This is a 170 lakhs. So it has to be in lakhs. The cost coming back.
It is not a court who should select the sites, which is relevant, which is not relevant, which is appropriate. Or it is the government office. In accordance with the procedure. If the court, the government finds it suitable in Jakarta, why you have not proposed in Jakarta in the first place? You should have done it. Why you have not done it? For not being by the government, court wants to enforce the course.
Imposing a cost in this case, for example, there will be a Jakarta was going to be. The interference, first it was
Given,
given to the motion previous.
why you have given,
Why do you?
if it is to be shifted. All officials led by the chief secretary has been declared as mad persons. Will be declared as mad persons of not knowing anything. Because everything will be cancelled. Everything positive, everyone is.
Tapi sebelum ini
When Lordship was expressing about the imposition of cost,
No, this is
can we come
absolutely,
to page 34, Lordship? Before any order is passed, I would like to place some documents, important documents, Lordship. Page 34. This is the minutes of the project appraisal committee, which was held on 28/8/2023. This has been reversed by the ministry impune order. And kindly come to the bottom sentence, last 3.1.2.
yes.
New proposals approved by the PAC. So kindly come to next page. As many as 21 projects have been approved for 23-24. The petitioner's village is at serial number 8 in page 35. Construction, multipurpose building, NH2, Musimti Mokchong, 100 lakhs. So this has been approved. Now kindly come to page 57.
Yes.
This is up to the Chief Minister has written the letter on 12/10/2023, and this is the direction of the advisor of Tribal Affairs and Election, Government of Nagaland. This was on 12/12/2023. Plan works under Article 275, Clause 1 during 2023, as mentioned, is allowed to the following
How are you a beneficiary?
beneficiaries and firms. And can they come to the next
No,
page?
Mr. Jameen, how are you a beneficiary?
My land has been donated and project has been prepared in my land. On my land.
No, how are you a beneficiary?
That
You
is how
have
I'm not-
donated the land means you have lost your rights, you have given up your rights over the land.
It is a benefit driven scheme, Lordship.
No, so this building, if it is constructed by the government,
Yes,
will be done in your land
yes,
and it would belong to you.
yes. No, it is for the community.
Then
is for the community.
why you are the beneficiary here?
My land has been donated, Lordship.
So how are you going to
And
be benefited?
entire public will be benefited by that, by my land.
But the other public, the village council or anybody has not come up before this court.
because you will not have the locus also.
They will have a locus, you may not. Because the benefit is to the village community.
For the, any project is for the community.
Yes, so that is.
Any
the-
project.
But
is
why
for the
it is
community.
mentioned out here, the beneficiary is so and so? Beneficiary means he has some benefit.
Can we come to page 44, Lordship? This is the NOC given by the all these projects has been done, starting from page 43. So many processes has been done. Starting from page 43. Land holding certificate, no objection certificate, request for land details, everything has been given, non-encumbrance certificate. Then the village council has also given the certificate at page 48.
So this project was the minutes by which this project was approved was given prior to your land holding certificate being given.
Yes.
Yes.
After getting the sanction, only the process will start from the deputy commissioner.
So they may have it in any other place also.
If they want to have it, the detailed project report is to be prepared against that particular village. That is my case.
So if it can be in any other
No
village.
detailed project has been prepared in respect of Jakpa.
Now understood. But if these two documents are taken out, page 45 and 46,
Yes.
you lose your locus.
Again, can we come to page 48? This is by the village council.
Yes.
He is the beneficiary, but the work is to be executed by a firm, which is in the page 58. The government has given, asked me to execute the work. Now, for allowing the
And why are you fighting so much? You are 98 years old.
that is why, Lordship, it is a
By the time the matter would end, you may not be there.
it is
By God's
difficult.
grace.
But Lordship, can we come to page 58? This is the list of the beneficiaries, serial number 6.
So why?
Construction of multi-purpose building at NH2 Museumti, location Mugokcho.
This
Beneficiary is Akang Thamjin, that is the petitioner, and the firm is MS Win Enterprise,
Win Enterprise belongs to?
some firm,
Not you.
not me. Because Lordship here, GST of 18% is to be deducted from the entire amount. 1 crore, 18% GST is to be deducted. And GST, an individual, the beneficiary, do not have GST number. Only a firm will have the GST registration. Therefore, giving in view of all this, the firm has been given to Win Enterprise, so that GST will be deducted, but the beneficiary's name remains the same. Who donated the land? Because the scheme itself is a beneficiary driven scheme.
How can you be a beneficiary once you have donated the land? I'm not getting the understanding that. Let us see the scheme which says how a person will be a beneficiary.
Out of so many applications, only 21 has been selected, Lordship. It is done by the state level selection committee, Lordship.
Grant of union to the state such sums parliament so and so, following the human resource by enhanced quality of life by raising the human is one of the to the state for tribal affairs must be plugging.
if it is to be located at Jakfire, then very well, the state government would have initiated the entire process, starting from concept note, detailed project report and all that. And the guideline says that SLEC should first approve it and it should be sent to the PAC and the PAC will approve it. The committee is constituted by the highly qualified persons from different departments. Lordship may kindly see from page 39 also, the general observation of the PAC with regard to the projects approved. And then in Roman 12, direction has been given to the states to obtain so many criteria, to fulfill so many criteria.
Now, the state government has complied in terms with this communication dated 8th of February 2024. Page 59 of the
59.
repetition.
Yes, ma'am.
Hmm?
This decision is not the decision of the PAC.
Oh, my lord, every step has been rooted through for relocation of the project to be constructed.
I'm sorry, Lordship. I would just like to draw your Lordship's attention to clarify one thing. This page 23. This is the continuation of the guideline issued by the Ministry of Tribal Affairs. Page 23, 12.9, last line. Funds under beneficiary-oriented project shall be released through TBT as per instructions of Government of India issued from time to time. So directly it will be transferred to the beneficiary, Lordship.
Why will the fund go to you? This is for construction.
Yes, no. The money will go to the firm who is making the construction.
So what
As
relation you
is
have with
mentioned
the
in page
firm?
49, 15.
Mr. Rami, I am not satisfied with your locus. No case for PI. No case for locus. You don't have a locus. The scheme, as I could see, there is no mention that there would be a case of a beneficiary by the name of a person. The entire scheme of the central government does not mention anything. It only says that it would provide a particular funding for the purpose of the benefit of the people. Now, under such circumstances, if the people are not concerned, why are you concerned? You cannot be a beneficiary of such action. Merely because your land has been donated, how are you concerned?
Lordship,
Unless
that's why
you are fighting for Mr. M. Win Enterprise.
that is why I'm referring to page 58. The beneficiary has been shown
As you.
against my name, and the firm
is so.
work is to be executed by the firm.
So unless you
Because
have
it is a beneficiary
because
driven scheme.
you are not going to get any benefit.
Yes,
So you actually the beneficiary should have been the village a community
Yes.
of so and so.
including me.
Yes, you will also be there. That must have been there, but that is not so. Why the beneficiary has been moved at you, and why a firm has been given to MS Win, unless you have some relation with MS Win.
Since my land has been donated, I have been given as the beneficiary.
So
But-
how does it have any relevance unless your name will be put out there in glowing letters that this
Lordship,
land has been donated?
That will be answered by the
Now something has to be
concept
there.
note.
Mr. Jamin, something has to be there somehow. How?
That will be answered by the project profile, Lordship, which I have placed before your Lordship. Because PSC takes the decision based in the concept note.
Difficult. Very difficult. For this court to interfere in these type of aspects is very difficult. But unfortunate thing, you will get a judgment which is smaller than the order dated 27/9. Because the question of this court interfering in these aspects, unless you show, yes, there is some malafidness. Yes, the chief minister for vested reasons, for some reason, he does not like our community, Maori have given it. So there is a violation of Article 2930. Then you may very well say that there is some otherwise some constitutional violation that by which the chief minister and the SLC have acted against your community. Say something to that effect, but this is not the case. It is absolutely within the domain to change it. They have changed it.
I fully agree with your Lordship, but at least this honorable court can interfere with the decision-making process, how the decision has been taken, not on the merits of the decision. It is within the prerogative of the government, but at least this honorable court can,
How?
the guidelines which the scheme is provided under Article 275(1) proviso. To implement that, the guideline has been framed by the Ministry of Tribal Affairs. guideline shows how it has to be implemented, in what manner it is shown. Paragraph 8 and 9 is very clear what is required to be done. Everything has been done. So
Your
before-
thing, therefore, I'm saying 28/8/2023 happened, whereby that your village was brought as a beneficiary. At that point of time, you were not in the scene. You came into the scene only on 10/10/2023. Okay.
yes,
So therefore, tomorrow, if that was not your land, some other land would have been given, you are out.
no, but everything process started with my land.
No, because 28/8 you did not submit any document.
No, Lordship.
Where is your land certificate given on prior to
Only
28?
after the location, everything is identified, sanction will come. Thereafter, only the deputy commissioner will start necessary formalities. That is just a formality.
So
But
the land certificate,
everything, location has already been identified before that.
the
And
land certificate will happen later on. Land certificate,
yes,
no
after-
objection certificate will be
Because-
taken later on.
after getting the sanction only, all these procedures will be followed.
So therefore, you come into the picture later on.
No, initially when concept note was prepared, my name was already there. I was already there.
How do
Because
you show me that document?
Lordship, kindly come to the concept note, the one which I have placed.
Yes. Where? Concept note doesn't feature your name.
Lordship, just above paragraph 3,
Hmm.
there is a sentence. So this project has been proposed at NH2 Mungsiemti under Mukokchung district, Nagaland, under the Department of Tribal Affairs. The schedule of rates will be as per the so-and-so. So NH2 Mungsiemti already earmarked
Only
the
your land is
location.
there. There's no other land. In NH2.
No, because this is the only place which has been earmarked, Lordship. And when everything has been done, only after getting the fund, a decision was taken. Okay, if Jakfa is found to be ideal, then you could have prepared a concept note, and then the detailed project report could have been prepared in terms of the paragraph 8 and 9 of the guidelines. And the letter of 8/2/2024 also says that you comply with the guidelines. It's like putting the cart before the horse. First, concept note, detailed project report, everything has to be placed. Thereafter, the SLEC should take a decision. And thereafter, it will be sent to the Ministry of Tribal Affairs, and the PAC will approve. Thereafter, the fund will come. Let them do that in that manner. But when everything has been done in respect of Mungsiemti, and when the fund comes, then there is some development, new development. So it has to be changed to Jakpa. In Chief Minister's letter 12/10/2023 mentioned that a new development. In the government affidavit and also in the private respondent affidavit, there is nothing. What is the new development? At least the government could have said that. What is that new development? So far I know only election. was held in 2023. So because of that, the change has been done. And the ministry was just waiting
So
for the letter of the chief minister.
Did the CM's party get some more votes because of that?
I don't know.
You have to vote someday.
So that is how this has been done, Lordship.
Okay.
So the decision-making process is required to be in effect with,
Decision-making process seems to be.
because it is in violation of the guidelines.
It's not in violation of
Issued by-
guidelines. How are you saying it to be violation in guidelines? The CM, who is the state in charge of this Northeast, whatever may be, he submits that there is a requirement that already, and the affidavit also shows that there is a community hall there next to it. Next year you will get it. Give it next year. Put it next year. But let this thing continue. Because I'm only worried with the lapse of fund. Central government is not bothered later on. The funds is just say nothing is happening.
Fund will not be lapsed, Lordship.
Huh?
And even the guideline says that the fund which has been allotted is to be utilized only for that particular project, and it cannot be used for other projects.
Therefore, this project now is Chapka.
Yes, ma'am. Yes, ma'am.
So it will be used for that.
They can also not execute it.
I have doubts, Mr. Jamil, with your locus.
In my affidavit in opposition, running page 20, annexure E. If my lord may kindly turn to
Annexure,
E,
page
running
20.
page 20. This is the communication letter. And the
Yeah.
minutes of the highest level,
Ever
state
written
level
the
executive
letter
committee.
addressed to the Honorable Chief Minister on the prayer of so and so, which is in next.
If I may be allowed to read, running page 21, my lord. This is the highest level state executive committee meeting. In the
Page,
running page 21,
this is something in handwritten.
this is in my state affidavit in opposition,
Ah.
running page 21. If I may be allowed to read. my
Yes,
lord.
yes, read it.
Minutes of the state level executive committee meeting, SLEC, held on 22nd March 2024 at 1 p.m. in the conference hall of the chief secretary to review all schemes implemented by the Tribal Affairs Department funded under grants by the Ministry of Tribal Affairs. The state level executive committee meeting was held on 22nd March 2024
No, I've read it.
here in serial 1.
No, I have read it.
Yes, ma'am.
By the time when Mr. Jamil was submitting, I have already read that. See, page 4, these documents is very dangerous for you, Mr. Jamil. Page,
And my lord,
lecture D2, respond number 4's document.
my lord, my affidavit page 10.
Okay, now
This
170
is the
lakhs.
completion certificate.
Construction have not started.
Is yet to start.
Huh?
It'll be started after the
TPR has
disposal of
not
this
been
case.
prepared. How they can start the work?
No, my lord.
TPR has not been prepared in respect of Chakpa. How they can start the project? Nowhere they have in their
No.
affidavit, they have mentioned about this.
No?
Nothing has been mentioned in their affidavit about the preparation of TPR, concept note, everything, nothing. Just that whatever is approved for CMD, that should be taken to. At least the guideline says that where the approval has been done, it has to be done in that manner. And the fund for which it is released should be utilized for that particular project.
But that has been changed
Yes.
by the central government.
Arbitrarily changed. That is how I am aggrieved, Lordship.
Why is this change been, there is the reason being given.
The only reason given is new development. Because my grievance starts from the Chief Minister's letter of 12/10/2023. When everything was sailing smoothly, the Chief Minister has written a letter to the ministry, DO letter. There he has mentioned the reason is new development. I'm questioning what is new development. At least let me know. At least let me satisfy after knowing that. What is the new development? So as to compel the state government to change the ongoing project. That is the only point I'm questioning.
My lord, if the
And the affidavit,
PDPS,
they have not said anything.
If 12/10/2023, that is much after the general election was over, not prior to the general election. It was
That's why.
much after the
The new
general
development
election
was
over.
the election only.
movement. The election was over way back in
Yes,
March
that's why.
2023.
Mr. Jamil, where is annexure K, original one? Annexure K.
And
to your-
K is my representation lordship.
Where is the original one?
If I may be allowed to read my para 5 manual to make the position very clear.
I've read your paragraph.
Okay, ma'am. The,
I've read.
yes, ma'am.
Where is the original of annexure K? Because the allegation which is being made by the respondent number 4 is a very serious allegation. That this is the document which was never issued by the village council. And they have put a certificate out there as annexure D to the affidavit.
But the village council has given the NOC.
NOC is a different thing.
Yes,
This
Lordship.
writing of a letter, and if you are enclosing some letter, because normally what has happened along with this letter, you normally enclose all other whatever language letter you are asking. You must have written this letter to the chief minister, which must have been in English. So why this was not enclosed? So should we now start to dictate?
Lordship.
I leave it to your lordship. Can we consider page 38?
The petitioner
Roman,
has approached this court
Roman
with
5.
unclean hands, Lordship.
Hmm?
The petitioner has approached this honorable court with unclean hands, Lordship. And as my lord has held in Pasanti Teka's case, Lordship, a litigant who approaches this honorable court with unclean hands deserves no relief.
On the strength of the government orders, I have approached this honorable court for violating their own orders.
No, Mr. Jamil, the one problem I'm finding is your locus. Very difficult. You cannot, under any circumstances, be said to be a, what do you call, beneficiary. And if you are a beneficiary, obviously you can. But how can you be a beneficiary?
Lordship, government has given me as the beneficiary in page 58, serial number 6. The Deputy Commissioner, District Administration has verified everything that is against my name.
This village council have given this communication on, what is the date? Page 11 of the affidavit filed by the respondent numbers 2 and 3. What is this date? Page 11? 24, some 24.
No take, my lord.
5/7/2024. So this was done on only on 5/7/2024. And if it was done on 5/7/2024, this is the photograph out there.
Yes, ma'am.
Then what is the justification that this court should interfere? When the state has said that it is in a better place, it's required. Chalo. Heard Mr. C.T. Jamid, the learned counsel, senior counsel, assisted by so and so appearing on behalf of the petitioner. Mr. You are appearing for?
For R2 entry, state respondent number 2 and 3.
Mr. Yangavati, you are appearing?
Respondent number
Mr. Yangavati appears on behalf of the respondent number 1. Mr. So-and-so appears on behalf of the respondent number 2 and 3,
along with Z.
along with Mr. V.G. Momi. Appears on behalf of the respondent number 2 and 3, and Mr. Santiago appears on behalf of the respondent number 4.
My lord.
The petitioner herein, please take a seat. Herein has approached this court challenging the change, challenging the decision of the respondent authorities to relocate the construction of the multi-purpose building from NH Mongsenimiti to Chakpao village under Moksung district. For the purpose of deciding as to whether the petitioner have made out a case for interference under Article 2 to 6 of the Constitution, this court finds it relevant to take note of the brief facts which led to the filing of the instant writ petition. Article 275 of the Constitution deals with providing of grants by the Union to the certain states. In view of the said provision, said constitutional provision, the Government of India, the Ministry of Tribal Affairs, have made the guidelines in terms with the proviso to Article 275(1) of the Constitution, whereby funds would be allocated amongst various states under the scheme, keeping in view the proportion of ST population in the state, tribal area, past performance, support for innovation, support for emergent need and for special purpose. The guidelines stipulate that the allocation of the funds would be in 2 phases. The first phase would be for in the first phase, the allocation would be 90%, and the second phase, the remaining 10%. Clause 5 of the said guidelines stipulates the prioritization of the activities, meaning thereby the relevant the various activities wherein special importance would be provided under the said scheme. The manner in which the funds should be allocated and the procedure to be followed has been stipulated in clauses 7, 8, and 9 of the guidelines. Clause 12 stipulates that how the monitoring would be carried out in respect to the funds allocated projects. First, for the year 2023-24, various proposals were sent to the Government of India by the Government of Nagaland in respect of grants under Article 275(1) of the Constitution. First, the said proposals so submitted were discussed and the Project Appraisal Committee, which consisted of various officials from the Ministry of Tribal Affairs and the Government of India, Government of Nagaland, took a decision to allocate various funds in respect to proposals so submitted. Amongst the new proposals approved by the said Project Appraisal Committee, one pertained to the construction of multipurpose building at the rate of 100, Unit 1 in the location of NH2 Mongsenimiti Mokokshong, and the total funds sought for was approved by the Project Appraisal Committee. On the basis of the said, report of the Project Appraisal Committee, the Government of India in the Ministry of Tribal Affairs, via the communication dated 6/9/2023, conveyed the sanction of the President for release of an amount of rupees 23 crores 25 lakhs to the Government of Nagaland for carrying out various activities as mentioned in the said communication. It included, amongst others, the construction of the multipurpose building at NH2 Mongsengi Imiti Mokokshung. First, it reveals that after that certain steps were taken by the Directorate of Tribal Affairs, Nagaland, Kohima, with the district administration of Mokokchung, whereby various documents were sought for. First, the district administration, the deputy commissioner on the basis of such directions issued by the Directorate of Tribal Affairs in the government of Nagaland, identified the land of the petitioner at measuring 4,593 square feet for the purpose of setting out of the multi-purpose project. Full-stop. While this process was going on 12th of October 2023, the Chief Minister of Nagaland requested the Minister for Union Minister for Tribal Affairs, that there is a requirement of a change in the location for the purpose of construction of the multi-purpose building at NH Monsenimiti to Chapka village, inasmuch as the villagers of Chapka village is a thriving community with immense potential, who would greatly benefit from the project being shifted to their location. It was also mentioned by the Chief Minister in his letter that this change in venue would address a number of pressing issues and yield significant positive outcomes for the residents. Full stop. Subsequent thereto, the Ministry of Tribal Affairs, Government of India, have approved the relocation of the project of construction of the multi-purpose building from NH Moniseri to Chakpa village under the Mokoksong district by following certain conditions, via the communication dated 8th of February 2024. The said decision so taken by the Ministry of Tribal Affairs as communicated by the communication dated 8/2/2024 is based upon the minutes of the meeting of the state level executive was based amongst others upon the minutes of the state level executive committee meeting held on 22/3/2024, wherein reasons have been assigned for changing the location from Moniseri to Chakpo village. The petitioner herein, being aggrieved, has approached this court challenging the letter issued by the Chief Minister of Nagaland dated 12th of October 2023. The minutes of the meeting of the state level committee, these minutes happen later on. These minutes, Annexure J, happen later on, after 8/2.
The minutes was,
Huh?
the state level executive committee meeting was held on 22nd March 2024.
But this decision of the ministry was taken on 8/2/2024. এইটো নিলিখিব হা
Eight
based
February
upon
2024.
huh?
8/2/2024.
have challenged the Chief Minister's letter dated so and so. The decision of the Ministry of Tribal Affairs dated 8/2/2024, as well as the state level executive committee meeting held on 22/3/2024. Primarily on the ground that the change so made by the impugned communication dated 8/2/2024 was not in terms with the guidelines mentioned in terms with the was not in terms with the guidelines. In as much as the said change of the relocation was made without the approval of the executive committee in the state, which was a fundamental requirement in terms with clause 8A of the guidelines. It is seen that pursuant to filing of the instant writ petition, this court, by the detailed order dated 27/9/2024, issued notice however, did not pass any interim order in favor of the petitioner. The record further reveals that the Chakpa Village Council, who would now be the beneficiary in terms with the impugned communication dated 8/2/2024, filed an application seeking impleadment to the instant proceedings. While in order dated 21/10/2024, the Chakpa Village Council was impleaded as the respondent number 4. It was also mentioned in the same order dated 21/10/2024 that a change of the project location regarding construction of the multi-purpose building from Mongmeng City Village to Chakpa under Mokuksung district shall be subject to the outcome of the writ petition. Mr. So-and-so, the learned counsel appearing on behalf of the respondent number 2 submits, 2 and 3 submits, that on account of the said order dated 21/10/2024, the project would not be started.
Yes, ma'am.
The report reveals that various pleadings have been exchanged on behalf of the parties. The affidavit in opposition filed by the respondent number 1 mentions that the annual proposal for the year 2023-24 was received from the state government of Nagaland by the communication dated 18/7/2023, which internally mentioned construction of multipurpose building at NH2 Mongmin City, Mokokchung as one of the projects. The annual proposal was considered in the Project Appraisal Committee meeting held on 28/8/2023, and the minutes of the said meeting was issued on 30/8/2023, which entirely approved the project construction of multipurpose building at NH2 Mongeng City, Mokokchung at a cost of rupees 100 lakhs during 2023-24. It was also mentioned that the ministry thereupon received a communication dated 12/10/2023 from the Chief Minister, Nagaland, addressed to the Minister of Tribal Affairs regarding change in the location of the project titled Construction of Multipurpose Building from NH to Mongens to Mongsengi to Chakpok village. Full stop. The office of the Minister of Tribal Affairs conveyed the said decision in view of the fact that the proposal is made by the Chief Minister of the state and the Honorable and the Minister of Tribal Affairs had advised to consider the same. On the basis of the same, the impugned communication dated 9/8/2024 was issued, whereby the relocation from so-and-so NH2 so-and-so Mokokchung to Chakpa village was allowed subject to following conditions. First, the respondent number 2 and 3 had filed their affidavit in opposition, wherein at paragraph number 4, it was categorically mentioned that the Chief Minister of Nagaland, being the Minister in charge of Tribal Affairs Department, Nagaland, proposed for relocation of the multipurpose building public hall from NH2 so-and-so to Chakpa village by the communication dated 12/10/2023 to the Union Minister, Tribal Affairs, Government of India, stating the reasons why it was required to do so. It was also mentioned that there is already a multipurpose building hall constructed at so-and-so village, and the completion certificate was also issued by the Extra Assistant Commissioner CHUYIMLANG Nagaland, which was completed on 5/7/2024. In spite of the minutes of the Project Appraisal Committee held on 28/8/2023, the Director, Tribal Affairs Department's letter to the Deputy Commissioner Mokokchung requested for land details letters dated 29/2023 and the EAC CHU Mokokchung's letter dated 10/10/2023 in compliance to the directions made by the DC Mokokchung. No effective work order have been issued neither to the petitioner nor to the newly located Chakpa village till date. It was also mentioned that the relocation of the multipurpose building from NH2 so-and-so to Chakma village also falls within the same administrative block. And moreover, in order to provide a platform for collective growth and development, the proposal for relocation was made in bridging the gap in core sector development. First, to the said affidavit in opposition, the petitioner, the respondents number 2 and 3 have brought on record the the no objection certificate issued by Monsenimity Village Council dated 5/7/2024, wherein it has been mentioned that the construction of the multi-story building at so-and-so compound under Mokokchung, funded by the Ministry of Tribal Affairs, Government of India, covered under the scheme of Article 275(1), have been fully completed with no objection. Full stop. The photographs of the newly constructed community multi-purpose building, multi-purpose building have also been enclosed to the affidavit in opposition. In addition to that, the communication issued by the director of the Government of India Ministry of Tribal Affairs dated 18/10/2024 issued to the Principal Secretary, Tribal Welfare Department, Government of Nagaland, was also enclosed, whereby the Ministry of Tribal Affairs, Government of India, had formally issued the communication after receipt of the approval of the SLEC for relocation of the project, and the state government was directed to implement the project in compliance with the terms and conditions mentioned in the minutes of the PAC meeting issued on 6/9/2023. Further to that, the land having been identified in the Chakpar village have also been enclosed to the said affidavit in opposition. That is for the division bench to look into it. Well, Mr. Jamil. This court further takes note of the affidavit in opposition filed by the respondent number 4, wherein the aspect that wherein the statements made by the respondent number 2 and 3 were reiterated. In addition to that, it has also been brought to the notice of this court that the annexure K to the writ petition was never issued by the Monsenimity Village Council, and to that aspect, a certificate have been enclosed as annexure T to the affidavit in opposition. To the said affidavit in opposition, the petitioner have filed the replies whereby reiterating its stand made in the writ petition. This court, on the basis, in the backdrop of the above pleadings, this court have duly heard the learned counsels appearing on behalf of the parties and have given an anxious consideration to the respective submissions. At the outset, it is relevant to take note of that the jurisdiction of this court under Article 2 to 6 of the Constitution is very limited. In the extent limited, in as much as the jurisdiction is confined to only look into the decision-making process of the respondent authorities. In the instant case, it would be seen that on 5/7/2024, the multi-purpose building at village Moswari to Ramtude Emtagad have been completed. The materials on record further show that in the Chakwa village there is no multipurpose building. The Chief Minister of Nagaland, taking into account the various aspects which have been duly mentioned in his communication dated 12/10/2023, had requested the Ministry of Tribal Affairs, had requested the Minister of Tribal Affairs, Union of India, to make changes to the to relocate the construction of the multi-story building from multi-purpose building from Moniz village to Chakba village. It is also seen that the respondent authorities, it is also seen that the respondent number 1, that is the Ministry of Tribal Affairs, have duly taken note of the requests so made by the Chief Minister of Nagaland, Government of Nagaland, and on the basis of such request have issued the communication on 8/2/2024, whereby the relocation of the construction of so-and-so to so-and-so have been approved, subject to certain conditions. It is further seen from the records that pursuant thereto, it is further seen from the very impugned order dated 8/2/2024 that one of the conditions is that there is a requirement of an SLC committee of the decision of the SLC to be placed before the Ministry of Tribal Affairs. The SLC thereupon, the SLC of the Government of Nagaland have thereupon submitted the minutes of the meeting, giving reasons as to why the relocation was necessary from so-and-so village to so-and-so village. This aspect have been duly taken note of by the Ministry of Tribal Affairs, and on the basis thereof have issued the communication dated 18/10. Where is it?
Lecture F to the beginning of position.
18/10.
Stage 2.
18/10/2024, whereby formally the relocation have been permitted by issuance of an order. It is also seen that from the very communication dated 18/10/2024, that the funds have already been released to the state during 2023-24. And therefore, the question of additional funds will be released. Therefore, the question of issuance, release of additional funds does not arise. First, this court, having taken into account the materials and record, do not, and so the submissions so made by the learned counsel appearing on the behalf of the petitioner, do not find, on behalf of the parties, do not find the present case to be a fit case for exercise of the powers of judicial review, taking into account that it is absolutely within the domain of the executive to locate the area wherein the construction of the multi-purpose building would be best suited.
Lordship, there is a basic difference between multi-purpose hall and multi-purpose building.
Multi-purpose hall.
Earlier, which was constructed this multi-purpose hall, it is only a hall which can be used for different purposes. That was only 50 lakhs, even the budget. But the present building is multi-purpose building, not the hall.
Multi-purpose building. You have
So
the multi-purpose
that
building.
has been mixed together
Yes.
with by the state respondents.
Multi-purpose building. multipurpose building best suited to decide as to where the construction of the multipurpose building would be best suited. First, this court does not, having perused the materials on record, do not find any ground, therefore, to interfere with the decision. Consequently, this court does not find any merit in the instant writ petition, for which the writ petition stands dismissed.
Much obliged.
For hearing, item number 5 and 6.
What is it? Too late in the day, Mr.
Malo.
Your matter is a partner matter. They should have called up.
Well, as your lordship has explained clearly, I've understood your lordship intention
Huh?
to it can be disposed of on that line.
Constitutional
Yes.
thought.
So I have nothing to play before you now. Because 2016, second writ petition is exactly what you have said. Of course, the only difference is that it is almost one decade back. That is 2016. As your lordship has pointed out, it is pending since 2016. You need-
I'll do one thing. I don't reserve judgments. I'll reserve it.
My lord, that is what I
I'll reserve it and take my time and then decide.
My lord.
Yes, what do you think?
That is what I am saying.
Fellowship, now the question of like having strict liability, applying the strict liability and all these things, Your Lordship. Now we have to see how the petition will also submit, Your Lordship. Because as far as the record goes, Your Lordship, we have seen that endeavor has also been made by the police personnel, like in reviving him also and taking him, rushing him to the hospital also. Endeavor has been made, Your Lordship, and nowhere, Your Lordship.
No, madam, the question arises. When a person is in your custody,
Definitely, Your
how
Lordship.
can a person die?
Yes, Your Lordship.
By hanging. It's a very serious thing.
I know, Your Lordship.
There's a response. The principle of res locator will come in.
That's why, Your Lordship, at least like Your Lordship, let give an opportunity. So we will also submit. That's up to the court, Your Lord, to decide that. I don't have
Okay.
any issue, but at least.
Okay, when do you want to submit? Tomorrow?
No, Your Lordship, let
No,
the
he
petition
says that I know many things, so he would not further submit.
I have already given in my pleadings.
Yes. So he says he's not required. He has already given in his petition. So therefore, it is for you. Therefore, his specific submission of Mr. Longshore is very specific. Look here. This is a case of res locator taking into account that a person who is otherwise, when you are examining a person, you don't arrest the person just and put him inside the police custody. No. What you do? First, you take him to the doctor.
Yes, we have taken him, Your
No,
Lordship.
understood.
Yes.
Take him to the doctor.
Yes, sir.
The doctor, after examining him,
Yes, sir.
finds him fit
Yes, Your Lordship.
and then puts him, allows him arrest to be done. Now, finding him fit and allows him the arrest to be done, which has happened out here. So therefore, he was fit at that point of time.
Yes, Your Lordship.
If anything happens thereupon, it is absolutely within your negligence.
Yes, Your Lordship. One thing we should also take into consideration is that the petitioner, the accused, Your Lordship, he was under intoxication.
Under?
So under intoxication, Your Lordship, and therefore, Your Lordship, he could not be able to examine the.
So what are you, if he was under intoxication, what did you do?
No, Your Lordship, he could not able to. We could examine on that.
Then the
And-
doctor should have not allowed him to be put there.
Your Lordship, doctor has also.
That is the
written-
most important aspect.
Yes, Your
When a person is not in mental state, the doctor could not have put him along with others. This is a very important thing. Mr. Longshore, that day what happened, nowadays we go for inspection of the lockups. That's one of our administrative works we do, or new buildings are being constructed in everywhere. When we see the lockups, one very interesting thing. In a lockup, you cannot have a fan. Do you know the why? You cannot have a fan. The fan is not permitted because that fan may be used by the accused to harm him, or some accused may allow. Now, there is now a big problem which is being faced is regards a person in that lockup, there might be a person with disability in a wheelchair. How will he go to the bathroom? So you may require a ramp. Now in the ramp, it should be such, it should be of only basis of some PVC material. It cannot be hard. It has to be PVC material. Secondly, you cannot have these holdings because this may be also used. You may have an exhaust fan, which has to be outside. Means it cannot be inside so that the fan blades can be used. These are the parameters of having a lockup.
I completely understand your lordship.
And here you have a ventilator where a person hangs. Huh? Okay, you argue tomorrow.
Your lordship, no,
We don't get.
No, your lordship, whatever now the commission has actually given a statement, everything that I will be stating will be based on this.
Yes,
Off
please.
the record. What
No. You place absolutely on this.
Yes, absolutely.
Now the question therefore is you only answer me only one question. That if whatever may be, they may say no negligence, that's a different thing. The commission of inquiry was only asked to hold as to what was the reason of the death. The commission of inquiry came up and said that no negligence or whatever may be. Very well. But the fact remains that when a person concerned had died within the custody,
Now, if we
what should be your reply? Just make your submission. I'm open. I keep on changing. Don't worry. I'll keep on changing.
No, your lordship, the thing is that I mean, whatever is written here, I cannot go beyond that, your lordship.
No, you can. You not only there. The committee, does it hold that there was a negligence on the part of the officials?
Not exactly.
Nothing.
No.
So you have a commission report in your favor. So the question, therefore, my question is to you, that let it be held that it was no negligence. But can a person who inside the custody, if he dies, whether there can be a responsibility of the state by applying the principle of res ispa locita?
As far as that law is concerned, your lordship, I have nothing to say, your lordship.
No, you say, please.
Your lordship, the one thing.
We'll hear you. Don't worry. I will hear you. I will give you time. No, you argue from here. I will hear you in the principal seat also. Don't worry. I'll give you enough time because this is a matter. You see, in other matters, I don't finish this off. But this is a matter I'm giving so much of time because of that. Because this is a matter of writing something which this court may have to write, taking into account the manner in which a person can die, because there are various guidelines issued in Durgadas Basu, isn't it?
Your lordship, the thing is that I also have to go through. Yes, your
Please,
lordship, my case might be bad.
You take
So
your
sometime
thing.
maybe
I will have this matter in the principal seat
Yes, your lordship.
on 22nd April. By the time you'll be ready.
No problem, your lordship. I also go through the rulings, your lordship, and at least
At 2 p.m.
give a submission
At
and
2 p.m.
the rest.
I'll give you time, madam. Madam, it is not that I am against you. Don't think it.
Yes.
But only thing is, if you come up, I'm very open to that. You come up, I'm having it on 22nd of April at 2 p.m. Okay?
Much obliged.
The hearing being almost complete and some further arguments is to be made by Ms. So-and-so, the learned counsel appearing on behalf of the respondent. This court directs the matter to be listed on 22nd of April 2025, showing it as part heard. Full stop. The scanned copy of the records be transmitted to the principal seat, taking into account that this court would be this court would be holding the roster at the principal seat first on 22nd of April. So the matter be taken up at 2 p.m. Would be taken up through RVC mode at 2 p.m.
Yes, CBI counsel.
Please, everybody's name would be recorded. My orders are never like this. I record whose name it is.
My lord,
It
for
is only-
this appearance, for this appearance, I'm also.
Yes.
You put your name, na? Everybody's name. You see my list.
It's in the course list.
No, Mr. Counsel, how it comes? My order sheets are like this. Here, Mr. Imchi Leong sir, he appears. So everybody who appears, their names I put it.
March what?
You also make your submission. Yes, central government, CBI.
CBI, my role is very limited. I'm only in read petition 241 of 2016.
That is
Where
inquiry.
the petitioner has implemented as a new respondent. So my role is very much limited to that extent. So I,
No, I think your role is over.
yes, here, if
Or
we are
yes.
supposed to go on the
Yeah.
other read petition, my role is
Yes.
over. My lord.
Your role is over because I have already had the commission of inquiry.
Yes,
Yes.
yes.